Tā ir. Aivi, tur varēs vēl viena flashka prezentācija pēc. Man liekas, sports tur viens vēl ir. Nu, Elīs, tu ierakstīji? Tev nav gadījumā flashka? Man ir. Iedos lūdzu Elīzai.
Viņai ir flashka, viņa vienkārši nav pārrakstījis.
Nu, varbūt tad arī sākam.
Kādā formā šis viss ir paredzēts? Jau sāk. Tā.
Okay. Tā, man redz tādu? Good morning, ladies and gentlemen. I am Dr. Lauris Sasnach, docent of Faculty of Law, University of Latvia, and today it is my great honor to moderate and also later today to participate in this conference about competition law, restrictions and economically reasonable approach. First of all, I would like to express my sincere gratitude to Faculty of Law, University of Latvia, for supporting this idea about this conference already in the third year in a row. And also, I would like to express my deepest gratitude to Ms. Inga Reine, Judge of the General Court of European Union, and to Ms. Linda Medenia, Advocate General of European Court of Justice, for kind support and help in organizing this conference. And for the opening speech, I would like to give a floor to Professor Jānis Kākliņš, Head of Civil Law Department of Faculty of Law, University of Latvia. Professor Kākliņš, the floor is yours. Professor Kākliņš, the floor is yours.
Thank you. Dear conference participants and guests, it is my great pleasure and honor to welcome you at the conference Competition Law, Restrictions and Economically Reasonable Approach. Thanks to my colleague, Assistant Professor Lauris Rasnach, it has become a tradition to deal with competition law topics on a regular basis. Every year, professionals working in the relevant field meet in this format to talk about current topics in competition law. This year's conference is focused on finding a balance between restrictions on competition regulation and economic development. As it can be seen from the agenda, the issues covered at the conference concern a variety of issues relating to competition law. As a professor, I am especially pleased that there are also speakers who are students and who have proven themselves in the study process as very successful students. Competition law topics are relevant not only to the world, but also to Latvia. In recent years, there have been a number of cases in which the Competition Council of Latvia has seen violations of competition law, and many of those cases are in the court right now. As we know, several cases have gained a lot of attention from the society of our country. I am convinced that this conference and the papers presented here will benefit every professional lawyer, officials, advocates, judges, and so on. Also, the views and ideas presented at this conference will be useful for students who are studying competition law course or want to connect their professional life with competition law. To all speakers of the conference, I wish you a smooth language, deep discussions, and a feeling of good work done. Thank you very much.
Thank you very much, Professor Kakliņš. And now I would like to give floor also for some opening words to Ms. Laila Medina, who, as I already told, is one of the persons who deserves special gratitude for all the kind support for this conference. And this year we are not only celebrating the third year of our conference, but we are also, in a sense, celebrating 50 years from Continental Can case in the year from the European Court of Justice, which is one of the landmark cases in European competition law. Ms. Medina, the floor is yours.
Good morning, everyone. I hope I can be heard and seen as well. And I would like to send the regards from Luxembourg, from the Court of Justice, which indeed in 1973 rendered a judgment which is considered as a first one which introduced merger law in European competition law scene. And at the time, it was seen that the merger is kind of something like blameless. It doesn't really affect competitors or the consumers. And in that judgment, it was for the first time when the court said that although seemingly on the surface it can be blameless or without specific consequences, it can in certain circumstances amount to the abuse of dominant position. And at the time when the judgment was rendered, the Times, we all know the Times as one of the leading medias, wrote about the case that it is arguably the most important test case in EEC legal history. Of course, I wouldn't claim that this case can be compared to the cases of the constitutional value, which are the basics of existing legal order in EU. However, I think the case deserves to be mentioned and deserves to be celebrated, as it is really seen as a beginning of the merger law in European Union. But before I talk about the specificities of this case as a part of this anniversary speech, I would like to just a little bit step back in a history to show the background against which the case came to existence. And we have to step back to the 19th century, beginning of 20th, when there was first observance of real economic impact of big economic powers, big companies, which from time to time were even seen as more powerful as the state in impacting the economic development. And specifically, that was the case about the companies coming from the United States. Together with the historic, this view from the late 19th century, beginning of 20th century, and the consequences of the Second World War, when the uh, founding members of the European communities at the time saw the impact of the steel and coal industry, it was decided that there is a need to have the articles regulating the competition. And these are the famous articles 85, 86 at the time. But the legal researchers admit at the same time that when those articles were inserted, there was not much of the study how these kind of rules could impact the economic development in the European continent. And these were actually the years of the 60s and 70s, which showed the practical strengths and the structure built within those articles. And therefore, the judgments or the activities of the Commission of the time are the ones which are setting the red lines or the first emerging rules regarding the competition law. In 1965, the Commission for the first time announced that the mergers should be seen under Article 86, but no further action actually followed until the beginning of 70s, when in 1971 the Commission adopted the decision in the Continental Can case, where it argued that the behavior of this American company within German market has amounted to the abuse of dominant position. And this is this Commission's decision, which was appealed at the time to the European Court of Justice, which was the reason of having the judgment from 1973, February 21. So exactly 50 years ago and some couple months at the time. One has to also remember that at the time there were no secondary legislation regarding the mergers, and this was the question of applicability of the treaty, the situation of the concentration. So a little bit of the facts of the case, very shortly. This was, as I said, American company, Continental Can, which through its subsidiaries in Europe had acquired shares of one German company, which was also busy in the same market as Continental Can, that's the packaging market. And the Commission considered that this acquisition of the competitors in a German market amounted to a situation which can be already seen as abusive, and announced in its decision that it's abuse of dominant position because of the concentration. Of course, the company disagreed, appealed the decision, and the case arrived to the court. Interestingly enough, although this is seen as a landmark case, at the same time, the result of the case is actually that the court annulled the decision of the Commission, considering that the arguments in the Commission's decision were not sufficient. And because of that, the both parts of the dispute claims the victory in the case. And why so? For the Continental Can company, it's evident because the Commission's decision was annulled. Why the Commission was pleased, it was because the court agreed with the legal reasoning of the Commission that actually the mergers are under Article 86, and also what are the legal interpretation of that article with respect to the merger. And what are the most important legal findings of the court within this judgment? And one of the first and most important, of course, is the very fact that the court agreed that the mergers are subject to Article 86. But other important matter, which is underlined by the legal researchers of the time and agreed also later on that the court relied on the objectives of the treaty itself to interpret Article 86. And by doing that, the court put the emphasis on the effects of the abusive behavior or abusive merger, and uh, it was dismissed that it's not important how the companies had alleged abuse achieved. The important aspect is the effects of such concentration to the market and the end result being abusive. And the court used the articles of the treaty describing the aims or the objectives in the competition regulation and stated that the existence of institutions of a system ensuring that competition, the common market, is not distorted, that a behavior of the company should not undermine such existence of the institutional system. And the court said further in the judgment that creation of cartel or the merger of the companies which can distort the competition should be treated in an equal manner, and that there is no difference between the cartel restricting competition or the merger and its impact on a dominant position of the company. And therefore, the court held that Articles 85 and 86 are part of the comprehensive system of the protection of competition, and that's why any kind of behavior which can impact the competition should be treated equally and should be equally prohibited. And the passage of the judgment, which deserved to be celebrated now 50 years later, is as follows. If Article 86 of the EEC Treaty is so construed with regard to Article 3F, and that's the article which talks about the objectives of the treaty, the strengthening of the position held by one enterprise can be an abuse and prohibited under Article 86 of the treaty, regardless of the methods or means used to attain it, provided it has the effects described above. And with the emphasis of the effects and dismissing the need of causal link between the dominant position and effect produced, also dismissing the need to establish exactly what kind of behavior caused as long as there are effects, and without need to prove any moral wrong caused by the company, it was argued by doing so, the commission, the court strengthened the position of the commission and provided the legal reasoning which should be used to prove the anti-competitive behavior of a company. And the legal researcher of the time in 1974, James Harwitz, in Hastings Law Journal, wrote the following. The Continental Can case is a true landmark decision and has significance far beyond its major holdings that Article 86 applies to situations involving the mergers. So what did he argue? He argued that the use of policy-oriented interpretation of Article 86, which required that it is only the aims or the effects should be analyzed, is a turning point in understanding of treaty provisions related to competition policy. And what he said as more generally, that general use of broadly worded objectives to determine the scope of more specific statutes could make interpretation of Rome Treaty more expensive, more capable of dealing with current problems, and more unpredictable than it is at the present. And we talk about 1974. Now, when 50 years have passed since 70s, we can see that there also has been more than true by holding that the EU law will develop and its scope will be very broad, and the court will use this interpretation to deepen and to widen the application of EU law in all areas of the legislation developed further on. But returning a little bit back to Continental Can case and why it is important to talk about it even today, because it has been argued that by adopting merger regulation and by having a detailed procedure specifically dealing how the mergers should be controlled and by introducing also ex-ante control of mergers, the importance of the continental case has diminished, or some have been arguing that almost it has disappeared at all from the table of the valid law. However, a case which appeared in 2020 in in France has put this question again on the table, whether continental can case law is still a valid case. I will talk more in detail a bit later on in my second presentation in this conference, but just as a little teaser, I will quote an article, a headline of an article from 2022 in the Competition Forum, where the author of the article analyzing this case in France asked the following: is the resurrection of continental case ex-post merger control appearing again? And what the National Court asked, in essence, whether the interpretation given in 1973 judgment is still capable of applying to concentrations which are below the limits set by merger control regulation, and can it still be undergo the ex-post evaluation, even though they were not required, these possible mergers to be controlled under the ex-ante control provided in the merger regulation. What was the answer of the European Court of Justice? I will give in just an hour's time, but I would like to conclude my introductory speech by congratulating once again the European Court of Justice by rendering its judgment in 1973 and by paving the way for development of merger regulations and merger rules in the European competition law. With this, I would like to thank you for your attention and wish everyone in the conference good luck, good discussions for all the topics which are included in today's agenda, and I will give back the floor to the organizers of the conference. Thank you.
Thank you very much, Ms. Medine, for your already kind presentation, and we are looking forward to hear your another presentation a little bit later. But currently, I also learned that due to some reasons, my own introductory speech could not be heard online. Therefore, in case if you just joined this conference online, then today we have a competition law section, restrictions and economically reasonable approach, and I am a docent of Faculty of Law, University of Latvia, Dr. Lauris Sasniņš. And yes, with that, our challenges for holding this conference online a bit continues, and our Polish colleague Dominik Wolski has not connected yet. Therefore, if possible, I would like to invite my fellow colleague Agris Bitāns for presentation. Please.
Thank you. So I would like to find my presentation, hopefully. So it seems, yes, thank you. So I need to set up time also. Be sure that okay, I will use your phone. Thank you very much. So my presentation today is about practical challenges in application of Part 3, Article 21 of Latvian competition law. And before I will start, I would like to make some small remark or disclaimer. Yes, I will a little bit refer to the cases where I participating as a lawyer, but I hope my academical position will be enough objective or at least independent to present this case, because I will mostly address to some practical challenges I'm faced, and I believe you will be interesting also listen. So this is a text of this particular legal norm, which seems very obvious. Yes, infringement if infringement is a cartel agreement, it is presumed that the infringement has caused a damage. And this, as a result, with a price increasement, about 10%, unless proved otherwise. So, and this practically started used in one very well-known cartel case, the largest so far in Latvian Competition Council history. The Competition Council fines 10 construction companies for participating in cartel. As you can see from publication from Competition Council webpage, the fine was totaling 16.7 million euros. So far, it's the largest fine introduced or applied in a history of Competition Council. Yes, but that is maybe it's one substantial background fact. But as regarding particular dispute or presentation, question is about what is a cartel agreement? We could use one of the more popular definition. Cartel is a group of similar independent companies which join together to fix prices, to limit production, or to share markets or customers between them. So, and question is when such kind of situation, legal cartel could be established. Of course, it should be established by infringement decisions, by competition authority, council, or court, or any other specific institution which is authorized to do so. Usually it's not create big problems and issues. However, here it's a very interesting situation. We have, this case, a hybrid decision. What does that mean? It means that Competition Council in one decision decided to fix or establish infringement or violation of competition law and fine participants. And once more, in addition, they also accepted or agreed a settlement because one of participants agreed to conclude settlement agreement with the Competition Council. This is a normal practice. However, usually these two types of legal acts sometimes are divided, and maybe there is a reason to do so. So all companies challenged the decision, of course, except the one company who signed it or concluded settlement agreement with the Competition Council. And the next fact, it's the two claimants initiated civil proceedings, cartel damages actions, against the defendant who particularly settled this case with the Competition Council. And the claim had been justified or under Part 3, Article 21 of the competition law. And challenge number one in this case is the following. Whether the infringement as a cartel agreement is established already under Article 21 of the competition law. Because only one person, we could allege, at least allege, that somehow agreed or accepted this potentially participation in illegal actions. However, the rest of participants did not accept it. Also, they challenged. These conclusions from Competition Council. And as we know, agreement at least requires two persons or two parties to be established. In this case, as I mentioned, it was a hybrid decision. And since hybrid decision is challenged, question about is it a violation proven or not? Under Article 250/69 prim of the Civil Procedure Law regarding dividing burden of proof of infringement is stated very clear. Violation of the competition law needed not to be proven anew upon examining claim regarding reimbursement of losses if such violation, there are two preconditions. First, has been established by decision of the Competition Council, and second, the decision has entered into effect. So, in this case, unfortunately or fortunately, but this decision is not in force yet. The next, the largest part of what I would like to address is the quantification of overcharges or damages as it would be potentially for compensation. Latvia adopted presumption of overcharges in case of cartel agreement. Latvia is one of the 3 EU countries which adopted such approach. I will not discuss why and is it good or bad, but we accept it as a fact. But but it's clearly stated that this presumption is rebuttable. So that means it's not guaranteed, but it's possible to prove otherwise. And challenge number 1, how to rebut this presumption, and in which form, and what would be more reasonable instruments legally to do it. Under Practical Guide of European Commission, which had been adopted in 2013, very classical or general statement which said that quantification should be based on comparing the actual position of the claimants with a position that they would not find themselves if this infringement will not occur. They would. So this restitutio integrum, the main principle, which is very well known in civil law, is applicable also to these claims. And based on this practical guide, there are several methods mentioned as an appropriate one for quantification is comparison over the time, so-called before and after, comparison with an unaffected market, also call it yardstick, regression analysis, also call it econometrics, simulation model, and other methods. So we see that there is possibilities to use other methods in quantification of losses. Also, it's possible to use the same methods also to rebut the presumption. In this case, I will mention several challenges, and one of the challenges is the expert witness statement. So the court of the first instance stated the expert's conclusion, and I will quote, comparing the total costs of the building construction works and costs by type of work, the cost of design and outer supervision, taking into account the area of building and the works to be performed, and evaluating it with the cost of equivalent objects, the expert has no reason to doubt the adequacy of the costs. In the expert's assessment, the construction costs are appropriate to market prices of particular year, and court said cannot be considered as rebutting the presumption contained in Part 3, Article 21 of the competition law. So they rejected, saying no, it's not enough. And very interesting, what were the arguments? The expert made his conclusions several years after the completion of the construction works. Usually, all experts made their conclusions after. It is not possible to establish an exact calculation from the conclusions drawn by an expert. The expert has been guided by his previous experience, statistics, and previously collected information. Usually, experts only rely on their own experience. It is not clear what exact documents expert had in order to draw the relevant conclusions. Comparing the information with the average market situation in constructions or other procurements cannot be provided a completely accurate assessment of what the situation would be if the particular procurement did not have a cartel agreement. The experts' assessments of the large-scale economic evaluation with many variables and various criteria also allows for percentage errors. Therefore, in the opinion of the court, it is not possible for the expert to make a categorical statement that there was no price increase in the purchase specified in the claim. And in the expert's assessment, in that specific expert evaluating the documents at his disposal did not find any obvious inconsistencies. So challenge number 3, what are requirements to an expert statement in order to rebut presumption under Part 3, Article 21 of the competition law? Tax benefits. Construction works are subject to value-added tax, VAT, 21%. And the claimant, usually all claimants, use benefits from VAT by input tax. And challenge number 4, should this 10% presumption should be applicable to whole amount, including VAT or not? And when calculating amount of losses, whether tax benefits gained by the claimant should be taken in account as well or not. The claimant's benefits. It's very interesting. In one of the claimant was a subcontractor of the defendant and received payment for their services. As you can see, fee consisted together as 4.5% from the contractual amount, which is, I believe, substantial one. And challenge number 4, whether fee received by the claimant should be included in the calculation of damage. Official payments. It is obvious that in construction business, defendant should make an official payments or fees or duties to state or municipality institutions in order to prepare building force to put in operation or to registry in official registry, for instance, land book registry. And challenge number 4, whether official fee or similar payments made by the defendant should be included in calculation of damage or not, because it is impossible to overcharge these official payments. Mitigation of damage. The Central Finance and Contracting Agency made calculation and request to repay part of the EU co-financing amounts due to the decision of the Competition Council. There is a European regulation which stating that if there is a breach of competition law, that is a ground to recall back some payments or financing from EU fundings, which is obvious and clear. However, question is that claimant decided not to object or challenge of legality or justification of such request because based on the EU regulation, there should be independent investigation by the authority because the decision is still not in force. And also there should be found an impact to the EU budget, which is not fixed as well. So the challenge number 4 in this case, whether obligation to mitigate damage, which is a general obligation under Article 1776 of the civil law, is applicable to the claimant in case of recovery of loss caused by the cartel agreement. Here you can see the text of this particular legal norm. And as you can see, there is a general obligation to victim take reasonable measures to prevent losses which are reasonable under relevant circumstances. And question is, if somebody gave up in the beginning, will not try to challenge, is it enough or not? Of course, that would be possibly evaluated by the court, but this is a practical challenge because it's included as a ground for the claim of the claimant. So I now moving very fast, seems, to the conclusions, but it will leave us more time for discussion probably. Principle of restitutio in integrum is applicable in cases of cartel agreement, damages actions, and that is reasonable for both sides. From also it's applicable to the defendants and also the claimants. So because if a victim suffered some damage, it would be reasonable to receive full compensation, but nothing more as it's reasonable could be proven. Also, yes, presumption is making easier of the burden of proof, but does not eliminate or exclude it. So it still exists, and therefore, since general principles of the civil law and civil procedural law are applicable in cases of cartel agreements actions, it is recommended to check the existence of damage or losses in principle before submitting the claim of the cartel damages actions at least. Thank you very much for your attention.
Thank you very much, Mr. Bitans, for very well-organized presentation and interesting as well. Very much. And now I would like to invite Ms. Elija Siliņa for a presentation about umbrella pricing effect created by cartel and its impact on the market.
Good morning. As Mr. Lars Rasnic introduced, I'm Elise Siliņa, Assistant Attorney at Law at law firm TGS Baltic, and I will continue our private enforcement discussion with an quite unknown term called umbrella pricing, which is the effect created by cartels. And as was already heard today, in Latvia, private enforcement has become quite popular in the last years thanks to the well-known cases such as, for example, construction cartels case that was mentioned already. And however, looking at the case law existing in Latvia, we can see that actually private enforcement is not that well developed in Latvia. So first of all, regarding cartels. Cartels are horizontal agreements between competitors with the aim to distort or restrict competition. So cartels usually find themselves to either fix prices, divide markets, restrict input, or, for example, bid rigging, which is the most popular type of cartels definitely in Latvia. Looking at the existing examples where bid rigging is a case where competitors decide the terms on participation in public procurements, so to eliminate competition. And the European Commission in 2013 conducted a study and found that on average 93% of cartel cases lead to an overcharge, and the average overcharge is estimated around 20%. This is only average, and we can see from the diagram that overcharge may lead to even 70% of overcharge. And for example, in the United States, it's considered that the average overcharge is 25%. Based on this study, the Damages Directive, adopted in 2014, introduced a presumption of overcharge. So as Mr. Britans already mentioned, Latvia and 2 other member states have gone a step further and introduced a specific number for overcharge. So in Latvia, it's 10%. Besides that, there are also a lot of other negative consequences on the market. So for example, the cartels create this lack of competitiveness between the members, and this of course results in lack of incentive to make the market more efficient. Of course, also the cartels are a big turn-on for the single market economy of the European Union, and also of course the consumer welfare by paying higher prices is sent from the consumers to the members of the cartel. And in general, it can be seen that there are no benefits for cartels. As in other types of competition law breaches, there usually are some sort of justifications that can be found. However, in cases of cartels, there are no justification. And as ex-European Commission, the Commissioner has stated, the cartels are generally cancers of the open market economy. So what can be done and how to fight the cartels? In European Union, there are 2 the main pillars. It's private enforcement and public enforcement. Public enforcement is something that we all are very well aware of, as the decisions of the European Commission or private or national competition authorities are usually very loud cases. However, there is the other side of the coin, which is private enforcement, something that is not that well known as it's discussed in the national courts. And in general, the private enforcement was introduced in 2004 by European Commission. First, it was mentioned in the Green Paper, and the idea was that public enforcement itself is not enough. So public enforcement cannot ensure this full effectiveness of the EU competition law, as it only fines the individuals. However, it does not in any way correct the negative consequences created by the cartels. As you can see from the quote, it states that the full effectiveness of Article 101 would be put at risk if it was not open to any individual to claim losses. So any individual in the case law of Court of Justice has been interpreted very narrowly. So it includes, for example, public entities who do not operate on the general market terms and are politically connected entities. So there is this ironical example of the European Commission being one claimant in damage claims for the elevators cartel. So in the Commission building, there were elevators that were built there due to the cartel agreement. So it was found that public entities can claim damages. Also, damages can be claimed by entities that are not operating on the same market as the cartel. And there is also this economic continuity principle applied. So any individual is interpreted very narrowly. Here you can see the general consequences of types of claims. So from public enforcement, it's fines imposed by competition authorities that are increasing by time. So for example, in the well-known trucks case, the total amount of fine reached around 4 billion. Also, there is the prohibition to participate in procurements. In private enforcement, there are actual loss of profit, and payment of interest that have all been acknowledged by the Court of Justice of the European Union. Also, there is, of course, the damage to reputation and other factors concerned with cartels. Very briefly, to show how broad already the Court of Justice took this any individual that can claim compensation, there is, for example, the right for indirect purchasers to claim damages. So that would be the case, as we can see in the table, where the direct purchaser bought something from the infringer. However, the indirect purchaser, who on the downstream level bought something from the direct purchaser, could also claim damages. And to, so to say, make this passed on overcharge claim easier, the damages directive has introduced a also rebuttable presumption in the case of indirect overcharge, and the indirect purchaser needs to only prove the infringement, the overcharge of direct purchaser, and the fact that he bought those infringed objects. However, our today's topic, finally we have gone to it, is the umbrella pricing. So the Court of Justice of the European Union decided to go one step further and state that any individual also includes a case where, as we can see from the quote from Advocate General Cocotte, includes cases when members of the market that were not members of the cartel, so to say competitors of the members of cartel, have increased their prices due to the cartel, and those consumers of those non-members of the cartel can also claim damages. So they can claim them against the members of cartel. So creating this sort of huge like bubble of market that has been affected by the members of the cartel. So first, this umbrella pricing effect was acknowledged in decision of the Court of Justice in 2012, 2019 is the second decision, and it has also been acknowledged by European Commission. Here you can see that in general, the umbrella pricing and the reaction of the market can be divided by two cases. So either when those non-members of the cartel act as price takers, and here is an economic theory that we do not have time to dive into deeper, generally suggesting that either knowingly or unknowingly, other members of the market will increase their prices. And another strategy, of course, is when non-cartelists act strategically, when they see that their competitors have increased prices, and they will do it unknowingly. So what are the factors that should be taken into account is that to determine that spike, like this reaction from the market, definitely is the cartel's market share. So the bigger the market share, the higher the prices for the whole market, and it's easier for other members of the market to increase their prices. Definitely price transparency, where public procurement should be mentioned, that create a very transparent market, and competitors can easily see each other's prices. And there is also the duration of the cartel. So the lengthier the cartel, the bigger the impact on the market. So for example, I think that the longest known cartel found by European Commission was this animal phosphate cartel. So this cartel lasted for 35 years, and it had quite a big market share, those cartel participants. So I think it would be quite impossible to argue that in the period of 35 years, the market, besides the members of the cartel, was not affected by other members. So this cartel had created this huge impact on the market. And interestingly, on the average, in a study conducted by European Commission, the average cartel lasts for 7 years. So here we can see a scheme from all sides and all market participants that can bring a claim against cartelists, including this umbrella pricing. So we can see that cartels are subject to a very broad amount of entities that can bring a claim. So regarding this umbrella pricing that has been acknowledged by European Union Court, it's important to look at what role is played by European Union law and what role is played by national law. Why it's important that because in cases of national law, there are quite a lot of differences in the European Union member states, and it's based on the legal traditions of the member states, and there are quite a lot of examples in line of private enforcement where there have been significant differences. For example, due to in cases of stopping the proceedings while some decisions are of the competition authorities are decided. So there are those differences. And the general idea of the European Court of Justice that comes from one of the first decisions of the private enforcement, the Manfredi case, that in the absence of the European Union law, national law system should be the one to prescribe detailed rules governing the exercise of that right being the right to claim damages. However, with obtaining in line with two principles, equivalence and effectiveness. However, in case of private competition law, the case law coming afterwards, as well as quite detailed analysis of Advocate General Cocotte in umbrella pricing cases, as well as Advocate General Wall in Scania case, has suggested that this cannot be looked at that easier by national law being the one to determine the proceedings. The idea is that besides the principle of equivalence and effectiveness, there is also the third principle, which is the effective application of Article 101 Treaty of Functioning of European Union. And from this principle of effective application, there comes the idea that in case of private enforcement, national law should be the one that governs how the proceedings are brought, by governing procedural things like evidence, jurisdiction, etc. However, the right whether someone can bring this claim, like whether umbrella pricing claim can be both, should be decided based on EU law. And this can actually be seen from the existing case law of the Court of Justice, because Court of Justice was the one that decided on the umbrella pricing, as well as it has decided on those public entities being subject to damage claims, being the one to bring damage claims. So here you can see that the case law with the effective application of Article 101 that has been mentioned in all those umbrella pricing cases shows that in general the damage claims need to be seen from the European Union law point of view, like putting the national law a bit aside with this main aim to ensure effectiveness. And from a legal perspective, of course, one of the main issues is the causal link. So a claimant should always prove that the cartel is directly connected with the damages he has suffered. And of course, this direct link cannot be too remote. And the issue of causal link has been always one of the problematic one in case of like normal damage claims, not umbrella claims that has been acknowledged by the European Commission. However, definitely in case of umbrella pricing, this brings a lot of challenges. And the Advocate General Cocotte, for example, has stated that it's important to ensure that cartel members are not subject to unlimited liability. However, when looking at the sufficiently direct causal link, one of the aspects from the private law that should be examined is whether the damages were foreseeable. So whether members of the cartel were able to foresee the damages created by cartel prices. And here it's noteworthy to mention Advocate General Cocotte, which answered affirmatively to this question, stating that it's inevitable that market participants could not foresee that other market participants will raise their prices. And in her opinion, this criteria is definitely met, and there might be a sufficiently direct causal link. Also, umbrella pricing cases clearly shows that in case of private enforcement, the direct causal link is not equivalent to single causal link. So actions of those non-members of the cartel, which are not like directly which is not a single causal link for damages, can also, they do not like stop this chain of damages. And regarding umbrella pricing, as I mentioned, there are two cases in the Court of Justice of the European Union. This is the only existing case law that we have until this day in the Court of Justice of the European Union. So both cases concern the elevator cartel, which was a very lengthy, for several years lasting elevator cartel between the biggest manufacturers of elevators and escalators in the European Union. And so the first case of the umbrella pricing was quite general. So it concerned a claim bought by someone not a member of the cartel, of someone who had bought something from not a member of the cartel, and which considered that this not member of the cartel had increased its price due to the cartel. And in this case, also all the elevator, like the main transactions, concerned public procurement. So the price transparency was very high, and causal link could be proven. And the second one, a more recent one, which was decided in 2019, was a case when the province of Upper Austria granted so-called promotional loans to customers of cartel members for social housing projects. And the idea was that as the cartel increased its prices, also the amount of those granted soft loans were increased. And if the prices would have been lesser, like based on the market prices, the loans would have been lesser. And also in the second case, the Court of Justice affirmed that this might be the case to bring a damage claim. Of course, the Court of Justice of the European Union did not award or calculate any damages, as also in the first case, simply acknowledging this right to bring such claim. However, those two cases are very good examples on how far the European Union is taking the damage claims and how far-reaching the consequences on the market created by the cartel are. So they can go to all sides of the market. Of course, this umbrella pricing topic is also controversial, definitely, and there have been a lot of discussions about it, and I will not, due to the lack of time, look at all the controversy topics. However, the main one that has been discussed is the effectiveness of leniency. So leniency program was introduced in 2000, and which allowed members of the cartel to act as whistleblowers. So to say, to go to the European Commission or national competition authorities. However, this example is regarding the Commission cases, to tell everything about the existing cartel and thus receive immunity from the fines. We can see that in 2000, there is a huge spike in numbers of cartel cases, which is mainly explained by the leniency program. However, will leniency program be effective, and will it attract members of the cartel if there is this broad scope of damage claims? So we know that according to the European Commission's leniency notice, the leniency program, although it gives immunity from fines, it cannot safeguard the member of the cartel from private damage claims. Although there are some limitations, for example, regarding indirect purchasers and joint liability, however, this does not grant any protection. And one good example is the Lufthansa case, where Lufthansa went to the European Commission, received full immunity deal, but afterwards was sued by Deutsche Bahn for 2 billion euros. So this brings a question. If Lufthansa had known that afterwards coming damage claims, would it still have gone to the European Commission with this leniency application? And and here we can see also from the table, although this might be controversial, that we can see from 2014 the number of cartel cases is decreasing. So one of the suggested reasons is this adoption of the damages directive. So increased private enforcement decreases the initiative of members of the cartel to apply to the leniency programs. Also, it's important to know that as the public enforcement, the fines are capped with the 10%. Public enforcement is in no way capped. So the member of the cartel cannot in any how predict the amount of damage claims that it will receive. However, as an answer to the controversies and anything, there is, I think, in my opinion, a very good quote from Advocate General Kokot that states that the most effective way for cartel members to shield themselves is by not infringing the competition law in the first place. And that could be serve as an answer to all members of the cartel when discussing, when objecting to any damage claims coming afterwards. And that would be it for me. I'm really looking forward to discussion, and I will give floor to the next speaker.
Thank you very much, Ms. Silenia. Also, very interesting presentation. And, yes, I would like to check the status of also time. So the presentation was very precise. Well, but then seems that we could go forward with a discussion, and during your presentations I already made some notes, and maybe if you allow me to do that, I would like to address initially a couple of questions to each of you for the purpose of discussion. And well, maybe I will start with this question to Ms. Silenia. Yes, I totally agree with you that this umbrella pricing effect is a very controversial topic. But what is your opinion? This umbrella pricing effect could be presumed, or it should be and then perhaps refuted if it is possible, if there is enough evidence for that, or maybe it should be proved in the regular way.
Okay, thank you. So according to the existing damages directive and the case law that we have, there is no presumption regarding this umbrella pricing. And based on how difficult it might be to prove the causal link and all the other aspects, I do not think that the presumption should be applied to umbrella pricing, and that in those cases the members, the customers, non-members of the cartel should prove it by full extension.
Okay, thank you very much. Mr. Bittans, do you have any thoughts on this topic?
Regarding this topic?
Yeah.
Yes, I am the same opinion. This umbrella pricing, it's not a presumption, it should be proved. So, and yes, it's question how directly or indirectly you can prove this causal link. I agree. The largest market share, the longest participation cartel create potentially this effect. Yes, I could agree. But just by saying, I believe that everybody had followed your bad attitude, maybe it's not enough. It's not enough for myself.
Maybe as a follow-up, I think if the presumption were to be applied, it might create a risk, as the Advocate General Kokot implied, that it would create this unlimited liability for members of the cartel that definitely is not the aim of this umbrella pricing. This should only work when there is real umbrella pricing happening.
Yeah, thank you very much. My next question would be to Mr. Bittans. Take into account that you are established expert in tort law as well. What is your opinion about applicable causality theories? Would you think that existing theories, including adequacy theory and theory of protective purpose of norm and others, are sufficient, or some new theory should be developed and applied in the case regarding damages caused by competition law infringement.
Since the case law practice just started, it's not so clever to say that existing theories are not sufficient, and for that reason we need to create a new one. So I believe let's start sine qua non principle. It's applicable if you can see yes there is intention activities to create a price or overcharge. It's obvious. Okay. In some cases, this overcharging is not so obvious, and in some cases, for instance, if we will use the same umbrella pricing, it's very remote, yes, and therefore for this case maybe we need to create some new theory. However, for the direct losses, and as I mentioned already during my presentation, there are several practical issues which are potentially solvable by existing theories. But of course, it's in my view. But what will be a court position, we will see. We need to at least go through the proceedings with the existing cases because, as I know, there is maybe one or two maximum similar cases, but with a very small amount, with a very less disputable issues. So comparing this now after this construction company cartel case, I believe there will be several very interesting issues opened by the court through the court hearings.
Okay, thank you very much. And as I said earlier, this hybrid format of conference brings us some slight challenges, but now I do see that our colleague from Poland, Mr. Dominik Wolski, has joined us, and therefore I would like to suggest to give the floor to Mr. Dominik Wolski, doctor and assistant professor in Katowice Business University, Center of Antitrust and Regulatory Studies in University of Warsaw, with the presentation about balancing interests of the parties in private antitrust enforcement in case C-163/21, Pakar et al. And then, after presentation of Dr. Wolski, perhaps we could continue a bit our discussion. Dr. Wolski, the floor is yours. Okay. Well, Mr. Wolski, could you please switch on your camera? Yeah, and microphone as well. I do see you that you have connected. And if you are ready, you are welcomed to go forward with your presentation. No, I'm already writing. Okay, yeah. No, he's, yeah. Yes, and well, Mr. Wojski is joining us, and hopefully successfully. Just a small reminder, actually, our participants today is joining from 3 time zones, from Eastern European time, aka Riga time, Central European time, and also, yes, is on. Okay, Mr. Wojski wrote that he couldn't hear me.
Okay. Good morning. Can you hear me?
Yes, but we do not see you, at least yet.
You can't see me. Okay. Now it's better because I can hear you. I cannot see you, but still, you can't see me.
Not yet.
Okay, maybe I will reconnect. The voice is better, but the problem is that I see myself on the screen on Teams, but it seems that you maybe.
So I can see Mr. Wolski. Everything is okay from my perspective.
Well,
okay. So now I try to share.
yes.
Also, but can I share presentation?
Yes, please.
Just let me check if it works. Just one. Yes, here we are.
Yes.
Okay, can you see also presentation?
Yes, we do see.
Okay, thank you. So, may I speak?
Yes, please.
Thank you very much. So first of all, thank you very much for inviting me and having me in this conference or seminar. This is actually the first opportunity to speak at any conference in Latvia. So new experience, but great experience, I think. And also sometimes we complain that we have conferences, too many conferences online, but on the other hand, probably if I didn't have this opportunity, I wouldn't join. So thank you very much. I would like to share some thoughts or insights regarding private antitrust enforcement. And one of the recent cases, if we still may say that it's recent because it's from November 2022, in respect to one of the key elements of the damages directive, which is the disclosure of evidence. But before I will do so, I would like to share some perspective on the private antitrust enforcement, because in spite of the fact that from the implementation of the damages directive, we have more than 10 years, almost 10 years past, but still this is the kind of sphere and legal area that is not so much common even for many lawyers and both academics and practitioners. So to share a kind of state of play relating to the private antitrust enforcement, probably as some of you know very well, for many, many years in the European Union, private antitrust enforcement was almost non-existent. We, as opposed to, of course, to an American model where we have the antitrust or competition law enforcement. Probably in Europe is more common to say competition law is predominantly or mostly based on private enforcement. In Europe for many years we almost couldn't see any sign of private enforcement. I remember that I started it when it was the beginning of my academic interest in private enforcement. We were struggling to find any sign of private enforcement, even if it was not directly connected with some type of infringement or violation of competition law. But we still tried to convince our colleagues from practice and also from academia that no, but we believe that this is private enforcement as well, of competition as well, of competition enforcement as well. The situation, in fact, changed in the beginning of the 20th century. The first very well-known Carriage-Graham case of SEG, the SEG confirmed that based on the infringement of competition law, by and large, based on competition law enforcement, based on competition law infringement, we can also, or the injured party is also able to pursue private damages claims. And in 2014, we arrived in a situation when the so-called damages claims damages directive was adopted, and still sometimes I say and also write in my academic papers that our European attitude to private antitrust enforcement as opposed to American one is a little bit like to have a cake and eat it, because on the one hand we want to have effective private enforcement, and the European Commission came to the conclusion in the beginning, in the early 2000s, that yes, it would be nice to have private enforcement as well, because this will support the main pillar of the competition law enforcement, which is of course private enforcement. And this led to the situation in which we have a model based on the mixture of elements taken from the American model, UK model, and European Union model. One of the, of course, the focal points that was discussed at the time of the drafting the directive was the possibility to have so-called punitive damages, as it is in American systems, so treble damage system, which significantly helps private plaintiffs to pursue their claims in the courts. But in the end, as many of you are very well aware of, that in the European Union, in the continental civil law system, this is just not acceptable, because for us damage or compensation must equal damage. So that's why we couldn't cross this line, and we still have, as I said, something that is a compromise between the European and the American model. Still, private antitrust enforcement is behind the public one. And as I said, the main goal, the main objective, which has some relevance, as you will see in the case that I'm going to discuss, the idea that underlines the directive, all the rules that are in the directive is, of course, to support, to reinforce private enforcement by applying also this private one. And what I'm going to discuss today is, as I said, is something that is related to disclosure of evidence issue. And disclosure of evidence was one of the key pillars that damages directive is based on, because this is actually fair to say, and I have also experience as a litigator, as an attorney, not only as an academic, but also as a practitioner. And yes, this is true that this imbalance, information imbalance, you may say, we may call like this, between the parties in case of competition law-based private damages claims, it is an issue because also, as this is a kind of common knowledge, that if I did something wrong, probably I'm not bound to disclose it, and I'm not bound to show everyone that, okay, here is the evidence, right? Here is something that confirms that I did violate it. I did violate the competition law. Of course, on the other hand, I said that this was one of the key points of discussion, the moot point, if we may say so, when drafting the directive, the disclosure of evidence, because we have also the other values, like programs that allows or facilitates also private enforcement, like, for example, leniency proceedings, that is to very much extent at least might conflict with the disclosure of evidence rule. And that's why still, as you would see here, we have disclosure of evidence is still an issue when pursuing private antitrust enforcement claims. So here I would like to share the legal context of this Packard case. This is relating to the very well-known truck cartel case. Even some practitioners and academics that are not very much involved in private enforcement, probably cartel case is so very well known that almost everyone knows about the case, and it spread across the European Union countries, in many countries, even in Poland as well. I don't know how it's in Latvia, but in Poland for sure we have cases based on truck cartel case. And of course, one of the courts that also had to face the issue of disclosure of evidence within the context of this truck cartel case was the Spanish court. And what was at stake, and I believe that this is still at stake, even after the SCG ruling that I'm going to discuss also today and to share with you today, is the application of disclosure of evidence based on the interpretation of Article 5 of the Damages Directive. And why this is so? Why this is an issue? Because the directive is written as it is written, as every directive you know very well, that there is also a room for interpretation, but also the way how the directive is transposed to the national legislation is actually this is the room being left for the national legislator, which means that of course not only the interpretation but sometimes also the wording of the national legislation can differ when comparing this with the directive. Although I would also use this opportunity to say that in Poland it is rather the copy, at least to this extent, to this end, is rather copy-paste model. So what was in the directive was copied and pasted to the Polish legislation. And so still the issue of Packard case related or the interpretation of Article 5 of the directive is valid, is important. So there are two ways and I believe still there are two ways of interpretation of Article 5 of the Damages Directive. One is narrower, meaning because I believe that you have similar rule in the civil proceedings in Latvia, in Poland is the same, in Spain the same, in Germany. That of course at the request of the party, mostly at the request of the plaintiff, the court has right to order the other party, mostly the defendant, to disclose some evidence. Right? We in Poland we have Article 248 of the Code of Civil Proceedings that exactly reads as it is that the court can order to disclose some evidence that that is in the possession of the other party. But the issue relating to the Article 5 of the directive, of the Damages Directive, is whether the provisions of the directive, whether the rules that are included in the directive should be interpreted narrowly or broadly. So narrower interpretation means in the end that, and using the wording of the directive, that it should be so that the evidence that the court is ordering the other party to disclose should be circumscribed or identified as precisely and as narrowly as possible. So, based on the wording of the directive, we may say, so the literal interpretation, we may say that okay, this is the very narrow interpretation should be applied, right? Because disclose does not mean produce ex novo. I use this term produce to simplify. Sometimes I believe simplification better illustrates the main issue at stake. Sometimes we use as lawyers we use very complex terms, but sometimes to simplify is a little bit better way to explain what someone's means. So to disclose does not mean to produce ex novo. This is the narrow interpretation. The second possible interpretation is a little bit broader. So, and this is enlightened by the main goal of the directive, which is the effectiveness of private antitrust enforcement. And this in turn means that narrow interpretation could lead to the situation that can compromise the right to full or the right to full compensation of the party that suffered damage could be compromised. Yes, could be compromised. So no full right for compensation, I would say, simply speaking. So having said that, the second interpretation, the second way of interpretation could mean that disclose to some extent means also to produce. What does it mean to produce? To have not only to disclose that data that I have in my possession, so I don't have to do anything more than once the court ordered me to disclose, I just take what I have and send to the court saying, okay, this is what I have, that's it. Or the broader interpretation means that if I have some data that are not being got together and some work is needed, some work has to be done in order to collect data, to compile and to send a kind of report, for example, to the court. This is also admissible, yes, in the light of the directive. This is the broader interpretation, and this is the question that the Spanish court faced, and not wanting to answer, the court said, oh, okay, so it's better to ask for preliminary ruling of the SCG, and let's see what the SCG will say. And here we have very, very briefly the legal context that I have actually already discussed. So we have, I just want to pay your attention, to draw your attention to some lines in the Article 5 of the directives, actually the two of them, or three of them. So first of all, the Article 5.1 of the Damages Directive reads that national courts are able to order the defendant or a third party to disclose relevant evidence which lies in their control. Of course, subject to the conditions of this chapter. Then in Article 5.3, Section A, the directive reads that, okay, but it should be proportionate. So the legitimate interest of the party, of both parties, should be considered, which also mean that there should be a proportion between a need to disclose the evidence and some kind of ability of the other party and the effort that the party has to make in order to collect and send and disclose data and share data with the court. And what's more, we have also Article 5.3, Section B of the directive, which also reads and gives some very important guidelines, in my opinion, that this is the rule against so-called fishing expedition. So what the directive reads is that it should also prevent, the rules on disclosure of evidence should also prevent against some searches for information. So I don't know, maybe there is something, maybe there isn't, but just in case, I just try to check, right, and send a request to the court, or okay, the court, so please order the other party to disclose what they have. Maybe they have something, maybe they don't, but let's check. So as I understand the Article 5.3 Section B of the directive, this is actually this is particularly against this situation, against the fishing expedition rule. So having said that, and facing the question whether narrower or broader interpretation, the Spanish court asked the question to for the preliminary ruling of the SCG, asking exactly the question that I have just discussed. So if narrow interpretation should be applied to Article 5 of the directive when interpreting the national rules. So if does it relate only to documents in the control of the party, so which documents or evidence that exist at the time of ordering the party, or it also could be interpreted in a way that the party being ordered also has to produce something ex novo by compiling, classifying information, knowledge, and so on and so forth. So this was the question of the Spanish court that was sent to SCG, and I would say the SCG answer was basically what I sometimes call that this is the lawyer attitude. So you can turn right. I'd advise you to turn right, but mind that you can also, in certain circumstances, you can be able, or you can also, or you should also turn left. So it's up to you to decide. This is quite common how the SCG many times addresses the issues being sent to by the national courts. So what the SCG said, following actually the opinion of the Advocate General, which I will show you also very briefly in the next slide. So the broader interpretation long story short, broader interpretation is allowed, although you have to also apply the proportionate in a way that is relevant, proportionate, and necessary. So broader, but right? Still the court, as in many, the SCG, as in many cases, left the room for the national courts to decide. So you can apply broader interpretation, but always the responsibility is up to you. Always the responsibility rests on the national court to eventually decide whether the broader or narrower interpretation should be applied to a particular case. And as I also said, this is as in many other cases, this is quite common that the SCG follows the opinion of the Advocate General, and as it was in the case that I'm discussing, so the Advocate General gave or provided many reasons why broader interpretation of Article 5.1 should be applied. So it has to be interpreted in the view or in the context of the objectives of the directive, which is, of course, the effectiveness to reinforce the wider system of competition law enforcement in general, but in particular to make more efficient also or by making more efficient private antitrust enforcement. That what has to be taken into consideration is also the evidence. This is also based on the literal wording of the directive. That directive actually, but in a different context, by the way, a little bit different context, by the way, also reads that what reads one of the provisions of the directive is that, yes, the evidence other than in the possession of the infringer. But in my view, what does it mean is that other but already exists. But okay, this is one of the pieces of the directive, of the lines of the directive that the Advocate General also referred to, that we have to take into consideration when interpreting Article 5.1 of the directive, a relationship between the evidence requested and the claim for damages, meaning the effectiveness of this claim. So, because this is critical, this is of the critical importance for the national court to have evidence disclosed in order to allow the party to effectively pursue their claims. And of course, any interpretation of the directive should also help to achieve this goal. Because on the contrary, the interpretation of Article 5 of the directive, the narrow interpretation of the Article 5 of the directive, lead to the creation of obstacles on the way of pursuing effectively private enforcement case. But of course, in the end, also Advocate General, to be absolutely fair, mentioned that yes, but we also have to consider, or the court, when adjudicating the private enforcement claims, always also has to consider that the balance between the interests of the parties has to be kept or has to be maintained, as we may say. And as the closing remarks of my presentation, as I said in the beginning, that I'm academic but also practitioner, and I have long experience in civil courts and in civil courts proceedings, and that's why I'm very much interested in any interpretation of private enforcement rules, also relating to civil proceedings. And my comments to this end, so the interplay, I would say, between the need of effective private and antitrust enforcement and some basic principles of civil proceedings that are more or less the same in vast majority of European Union countries. I remember also one of the conferences that we organized in the Center for Antitrust and Regulatory Studies at Warsaw University. And as far as I remember, someone from Latvia was also present at this conference. And we discussed, this was before the interpretation of the Damages Directive, and after there is also the book that was edited discussing the issue of implementation in Central East European countries. And so so that's why I believe that we have more or less the same legal setting or the same legal framework of the civil proceedings. And so my comments are as follows. First of all, we like it or not, but antitrust damages claims fall under the scope of civil proceedings. And civil proceedings is based on the adversarial process, which in the end means, as I call it here, a battle of equal parties. So we have the same position, and in fact, the final outcome of the court proceedings pretty much depends on the parties' activity, right? And also on the situation that the parties are before the court when defending and pursuing the claim. So any rule that we have in the Damages Directive, and then it was transposed to the national legislation, should be also interpreted in the light of the basic principles of civil proceedings, where the interests of the parties should be properly balanced. Both defendant and the claimant and the defendant. Of course, on the other hand, and this is in fact the real issue that we are facing, is that the Damages Directive, having this main objective of reinforcing and making antitrust damages claims more and more effective, it is plaintiff oriented, right? So the directive gives many legal measures, tools to make, I wouldn't say to privilege, plaintiff privilege oriented, but honestly, it gives more space, more opportunity, more tools to the plaintiff to effectively pursue antitrust damages claims, and this inevitably leads us to this question of the model of civil proceedings to the end, in this context, in the context of private antitrust claims. And the final question is where interests of the parties in PACCAR case were properly balanced. And as the ESCG did, I will also leave you with the answer. I mean, with the question, because my answer to this question, my preliminary answer is that I'm not sure, and I'm really curious what is your opinion. Maybe you have some comments to this. I'm not sure if this interpretation does not go too far. So that because in the end we always will face this question. Okay, if this means, if the broader interpretation of Article 5 of the directive leads us to the obligation of the party to, let me say, to produce some evidence based on the data. So produce of evidence, what does it mean? It means only to collect, for example, data, which I already have. Okay, maybe this is not so far-reaching. Or it may also mean to extract data, challenge, in my opinion, from some sources, from some statistics, for example, right? So, of course, we still have the that it should be interpreted based on the proportionality principle, but again, the question, in my opinion, remains. So, for me, it is still a question mark, and let's discuss it. Thank you so much for the opportunity to share my views and comments. And of course, if you have any comments or questions, I'm really curious to know. I'm sorry because probably yes. Now I see on chat that I took too much time. I'm sorry about that.
No, but in any case, Dr. Wolski, thank you very much for your interesting presentation. Definitely, the disclosure of evidences are the matter which touches a lot of aspects, both regarding substantial and also procedural law. But I have actually one question before we are moving to the next section. And if I may ask you to provide one reason whether you think the directive, damage directive, I mean, you mentioned that it is a compromise between member states. What is your opinion? One reason. Is it successful or not so successful compromise? Please,
yeah,
if possible.
Thank you very much for this question. This is actually what we have been discussing and what we discussed before the implementation, when the directive was being drafted, and then after the implementation and the implementation phase. I would say yes, between the member states or among the member states, based on because I also some time ago I also edited and published a book including some review of national legislations in respect to private enforcement, but also there were a lot of discussion about, in the book, there is a lot of discussion about some legal settings of civil, substantive law. Yes, so how it was structured before the implementation and what was needed to change and so on. So yes, I would say that there is a fair compromise. What is in the directive, there is a fair compromise between the member states' legal settings. Although, as always, if you have the compromise that you might say is fair, you had to, at the time of when the directive was being drafted, you have to leave some room. You had to leave some room for interpretation, and that's why, because the more flexible, the more flexibility, and the more directive is flexible, you give more space or room to the national legislators to structure the national law. And then, of course, we have the cases like Pakar case, when the court national, because in the end the national court is decided. So my simple answer is yes.
Yeah, thank you very much. And yeah, with this I would like to conclude the first section dedicated to the private enforcement of competition law, and go to the second section about fundamentals and recent topics of the competition law. And now I would like to invite Ms. Laila Medina, Advocate General of the European Court of Justice, with the presentation about the rights and obligations of national courts and competition authorities, recent case law of ECJ and General Court. Ms. Medina, the floor is yours. Thank you.
Thank you, and I'm happy to come again after my congratulations speech to Continental Can case. I have prepared a presentation with some overview of the recent case law dealing with the competences of the national authorities. I hope you can see the screen of the presentation. Is it visible?
Yes, we do. Thank you.
Okay, so then I can proceed. I will, in my presentation, I will have a look at the recent case law. I will talk of some of the cases just very briefly, but in every case, I will touch upon the topic which deals with the competence of either national courts or national authorities. That is how the European Court of Justice or General Court, what they have recently said, how we should look at national competition authorities, what they can, what they can't do, and what is their status and how does it work in national context. In a way, building a bridge from the previous presentation, previous section to the next one. And I'll talk about 4 main points. First one will be the rule of law and the independence of the national competition authorities. The second will be of the non bis in idem principle, or what we shall do if there are 2 competing procedures involving the same companies or similar facts of behavior of the companies. The third one will be about the division of the competence when it comes to data protection. So what's new about that? And the third one is what is the competence of national competition authorities and the courts when it comes to direct application of the treaty. And that will be a link of my initial presentation this morning. Independence requirements for national competition authorities. This is, in my eyes, a pretty remarkable case because it's quite outside the competition law, where the European Court of Justice came up with a test which is now really well known or much talked about. That is the test how to see whether the national judicial authority, whether national court is complying with the rules of treaty with respect to rule of law and its independence. Famous case which comes out from arrest warrant directive. And the General Court used that principle established or used the test established in that case in the competition law area. Where we see the European Court of Justice created the rule, mostly addressed to national courts, and this test was taken over by the General Court and used to see how to determine the authority which is best placed to examine a complaint in the competition law area. In this Speed Pro versus Commission case, and you see on the screen the main keywords of the case, and as you see, this is just one aspect of the case. All the other ones I will not talk about. There, the General Court, in a situation where there was a Polish company in the rail industry complaining of behavior of another company controlled by the Polish state, submitted its complaint to the Commission, requesting the Commission to review its complaint and claiming that because of the problem of the Polish Competition Authority and possible conflicts of interest, there is a real risk that this complaint will not be reviewed in an independent manner. And to start immediately with the result, the General Court agreed that the Commission has not reviewed properly the evidence submitted by this Polish company, and because of that, the Commission shouldn't have dismissed the claim of the Polish company and should have properly reviewed and properly considered whether the requirements of the independence of the Polish Competition Authority is really existent. And the importance of this case is that the General Court applied in real life, if I may say so, this 2-step scenario. Firstly, detecting whether there is a general deficiencies with respect to the independence of judiciary and competition authority, and by concluding that there is an evidence, and we all know the situation and we don't need to go anywhere further with that. But what the General Court did is it applied also the second step, and that is it evaluates whether in this specific particular case that specific company was under the threat that its case will not be viewed independently. And it analyzed in detail the evidence, what the company had produced, and what it concluded that the Commission has an obligation to review in a detailed manner every single evidence produced by the company to conclude whether there is or there is not a particular threat in this individual case to the independent review of the specific complaint. And the court concluded the Commission failed to to comply with its obligation to follow this two-step evaluation test, and also the Commission failed to state the reasons. So that shows that in case as such, where a company claims that its complaint will not be reviewed in an independent way by the national authorities or in a competition law area or further on its judicial review, the Commission has an obligation to evaluate every piece of evidence submitted and also state the reasons in detailed manner why the specific authority is independent, or conclude that it is not independent, and thus the Commission or any other authority is better placed to examine a specific complaint. The next two cases I want to bring your attention to, these are two cases C11720 and C15120, bpost and Nordzucker and others. And these are the two cases where the Court of Justice has evaluated what to do if there are parallel investigations of a specific behavior of the company. And what is that? The court has to face and evaluate. In the first case, and bpost case, that was a situation where a behavior of company was infringing two sets of the rule. One was a rule relating to postal regulation, the other one was a competition. And the court agreed that in a case like this, if there are two sets of rules which are infringed, allegedly infringed by the company, both of them can be applied and the company can be penalized by breach of both sets of rules, although this is the same behavior behind it. And this is not a breach of non bis in idem rule, but with the conclusion, and I think that I can relate myself to the previous speaker, that there's always a condition, on a condition that these rules which are applied are clear and are without any doubt to the minds of the ones which are penalized, and also that the both authorities cooperate between the two, so there is no duplication in the penalties. In Nordzucker case, the situation was slightly different, where there was a question of possible impact of the company's behavior in two states. And also there, the court stated that both states have the competence to penalize or review the possible impact of the company, even if in one member state there is already a final decision condemning the specific behavior of the company. The other member state where the complaint is brought in later has also the rights to review this complaint, and if case be penalize the company on a condition that in that other second case, the competition authority may not rely on the final judgment in the first member state, but has to review the facts independently and collect the evidence independently on its own. The next case I would like to bring your attention. Here we have just the Advocate General opinion in Meta Platforms, another case, and that's a big case. And of course, there will be we'll see what the court will say in general in the case. But here I just wanted to bring to your attention one specific aspect, that in case where the competition rules are allegedly infringed, and it relates also to data protection, and that is the GDPR regulation, the competition authority, according to Advocate General, can also, but only incidentally, look at the infringement of the data protection rules, which can characterize the behavior of the company. And I think if the court will decide to follow this trend, that will be a very important aspect in all those cases where we deal with the companies which are in the social media using modern technologies and processing personal data. And we know there are plenty of them, and we know that this has been a reason of some of the very important judgments of the court. The next case maybe is not so important as, or actual as of this particular moment, but that brings me to the part where the European Court of Justice is discussing whether or not the national courts and national authorities have the right to apply directly Article 101 or 102. And that links me back to my morning's presentation of the Continental Can case, when the European Court of Justice 50 years ago for the first time argued that the treaty can be directly applied to the merger cases. And in this specific case, C819 from 19, in this judgment, the European Court of Justice reiterates once again that national courts have to apply the Treaty of European Union, that these articles are of direct application, and this is specifically related to cartel of air transport services, and it has also a certain linkage with the EEA agreement, where the court analyzes direct applicability of the EEA agreement, which is by its wording exactly the same as in the Treaty of Functioning of the European Union. And there the court has said that before the Regulation 1/2003 came into force, so we come to this relationship between the treaty and the regulation, so definitely before the entry into force of the specific regulation, national competent authorities and the courts have to rely on the treaty articles, and the same applies also during the transitional regime of Article 104, 105. And so this is yet again the reference case where the court once again repeats that it is a consistent case law of the European Court of Justice that the treaty articles are directly applicable, and both national competition authorities and the national courts can and should rely on these treaty articles when there is a claim of possible infringement on competition rules. Next case is a bit more nuanced situation where the court, the general court, and this is currently under appeal, and we'll see how the European Court of Justice will look at it. This is a Gazprom case, and there are many, many issues involved, but I want to bring to your attention only one single aspect, which relates to a situation where Commission in the case where the Gazprom had come up with the commitments how they could compensate the possible anti-competitive behavior, and the Commission had agreed of those commitments of Gazprom, but in that commitment it had not addressed one of the issues which was brought up by the respective private companies, what to do then. So if the Commission has not dealt with one of the commitments which was initially raised, but in a final decision not addressed, who is competent to address the possible complaint with respect? And that was in Gazprom case, that was with respect to Gazprom agreements with several member states of European Union. and this particular situation arrived in Poland again, and that was the Yamal pipeline as one of the possible commitments, which was not addressed in a final decision of the Commission. And what the General Court said, that it confirmed that even in a situation where in general the Commission has addressed the possible anti-competitive behavior of Gazprom, but a specific aspect hasn't been addressed, and if there are doubts left in the minds of those who started the specific case, then these are the national authorities and national courts which have the competence to view these complaints and come up with a respective decision according as the case may be in a specific situation. So even in a situation where the Commission has addressed in general the scheme, if there is an aspect which is left outside the Commission decision, that comes into the competence of national authorities and national courts. In this decision, you can also see the court's opinion what to do if there is an arbitration clause in such a commitment decision. And there the court views that in case of arbitration clause, this clause is not taking away the competence of the national courts to review a decision of such arbitration if it's viewed as not producing just result. So it reiterated that the national courts maintain their competence also if there is an arbitration clause in the judgment, in the Commission decision. And now I'm coming back to my morning introductory speech, which is case 449/21, and that is really a recent judgment from 2023, just a month ago. And as you remember, I talked about the Continental Can case, where in that judgment back in 1973, the court decided the treaty is directly applicable in case of a merger which can produce abusive effects. And as we all know, there is a merger regulation which sets the limits and which sets up the ex-ante control mechanisms, how to avoid abusive concentrations of the companies. In this case, there was a French television which acquired certain shares of a certain company, and thus left only one competitor in the French media market. And that competitor, Overcast, brought a claim that such merger, although they were below the limits of the merger regulation and also below the national competition law limits of ex-ante control, that such merger, however, should be seen as abusive, is creating the negative effects, which is amounting to the abuse of dominant position, and therefore the treaty should be applied directly, and such merger should be evaluated directly under the treaty rules. Basically, inviting French competition authority to apply Continental Can case law. French competition authority disagreed with this approach, so the case came to the national court in France, and unsurprisingly, French court asked the question whether the continental case law is still valid. And European Court of Justice agreed yes. In cases where the merger is below the radar limit of the merger regulation, and even if it's below the national limits, the treaty is applicable if such a merger can create the results in such a way that it can be seen as abuse of dominant position. And I would like to specifically refer to a very, very strong argumentation of the court, where it said that the reason why it came to such a conclusion, the court said any different interpretation would mean that adoption of a secondary legislation would rule out the direct applicability of provisions of primary law. And since it's well-established rule that the Articles 102, 101 create directly applicable, directly enforceable rights to private persons, the national courts have to protect such rights. And it says in its judgment, it is because the dominant position, abusive dominant position, is simply prohibited by the treaty. And therefore, there should be no exemption granted in a manner how it is dominant position has been abused. Therefore, national authorities must review that kind of cases and come up with their decisions. And in the court, in the judgment, explicitly says that the continental time case is valid and should be applied further. And the court, I invite you to read carefully the judgment. Court comes up also with the guidelines for national courts, how such review should be applied, and how the national administration and national court should view this kind of cases. So I would like to conclude my presentation with the congratulations once again to Continental Can case, that in 50 years it's not only celebrates its birthday, but also is still valid law, and the court has invited to apply it directly. I have one more slide, but I think that has been addressed already. That is about the damages directive and has been discussed extensively by the previous speaker. With that, I would like to thank you for your attention and give floor to my colleague Inge Reine, who will take over the floor and continue about the recent case law of our courts. Thank you very much.
Thank you very much, Ms. Medina, for your very interesting and thoughtful presentation. And as it was said, I would like to give the floor to Ms. Inge Reine. And as I said in the very beginning, which unfortunately could not be heard online, I would like to also express my sincere gratitude to Ms. Reine and also Ms. Medina for all your kind support to this conference. Thank you very much. And Ms. Reine, the floor is yours.
Thank you, Lauris. Now I will try to share the screen. Let me see if I succeed, which I think I do not. No.
Yes, we do see.
No, this is not. No, this is not the one. I'm sorry. This is the first time I'm using this. This must be the one.
Yeah, it seems so. Yes.
Now you should be able to see my presentation.
Yes.
Yes, it is indeed a pleasure to be with you for the third time, if my count is right. I think this is indeed a very good initiative, as the competition law is an important part of the European Union law, and our discussions every year show that there is room for debate, and of course there are issues that always remain in the shade or not entirely clear. Without further ado, I think my presentation comes very well after what Laila has said, with her very extensive summary of the conclusions by the courts on a number of substantive issues. But I also listened carefully to the debate earlier this morning, and I think I might provide with my presentation some insights into the debate of how national authorities could look at the situations. What are the important points? So what we know about the EU competition law is, first of all, the EU competition law sets out not only substantive rules, as you may know, we have articles of the treaty and then we have the regulation of 2004, but the EU competition law contains also a number of procedural rules, and this aspect should not be forgotten. And this is the combination of the two that gives us the right result. We cannot look at one without looking at the other. And of course, the newest procedural contribution to the EU competition law was the directive of 2019 to empower the national competition authorities to be more effective enforcers of the European Union law. The deadline for the transposition of this directive has just ended. The deadline was set of 4th of February 2021. And by 12 December next year, the Commission will have to produce a report. So we are living through very interesting times, and that is to see the efficiency of the cooperation mechanisms between the national competition authorities and the European Commission. As our president has said in one of the events, the essence of the competition law is that this is economic law by nature. It reflects an economic policy choice and relies on economic concepts. Why I recall this, this comes also very well in the context of some of the debate that was here this morning, that it is very difficult to apply just legal rules in the area of competition law because there are so many economic concepts that are difficult to understand, that are very complex, that require in-depth analysis and additional expertise, which lawyers do not necessarily have. And what we see as the main challenge at the European Union level is, of course, the Commission has very wide powers to enforce rules of competition. They can do it based on a complaint. They can do it based on its own initiative. They have very wide margin in imposing a fine of up to 10% of worldwide turnover of the companies involved. And if we see the evolution during the past 20 years, the last Google search engine fine remains unbeaten. That fine was imposed in 2018, which is 4.34 billion euros, which is an incredible amount of money. But this shows the complexity and this shows the economic impact of anti-competitive practices. And this is only what we speak of the maximum of 10%. So this 10% makes that incredible amount. So we're speaking of figures that go way beyond national budgets. And I will show you some of the figures that I have found. What challenge does it pose for the European Union courts? And well, primarily to my court, since we act as the first and the last instance, if I may say, most of the times in reviewing the facts of the case, because we're the court of direct action, which has the main task of looking at facts and evidences of the case, while the Court of Justice is looking at appeals on points of law. So the Court of Justice looks at our judgments from the perspective of how we apply and interpret the law, but the facts remain with us. We have to look at all those very complex cases that touch upon the very complex economic analysis, but we're not economists. As much as we would want to be, we could never be so. That means that we need to find procedural tools and solutions to allow us to adjudicate the case with the necessary quality and deliver justice. The national authorities may be dealing with lower figures in terms of fines, but the challenges in substance, procedural and substantive challenges remain the same. Also, national judges must deal with complex economic analysis and complex economic factors, and they must adjudicate the case on the merits and to the certain standard of quality. But in addition to all that, we must remember about the length of proceedings. That complex quality requires time, but we're always running against the clock, because what is important for us at the end of the day is that justice must not only be done, it must be done in a timely manner. So when we look at the fines at the evolution over the last maybe 10 years, I have found some interesting statistics. We have evolved from fines, and again, please remember that we're speaking about 10% of the global turnover. These are figures that show just 1/10 of the economic turnover of the companies involved. So we have started from several million euros, which is less than $500 million, to what, about 9 times that much? Well, no, more than 10 times that much in 2018 over the period of 4 years. Because if we look at the Servier, which was in 2014, but if we look back at the Hoffman case, which was in 2001, which is less than $500 million, then in 2018, some 17 years later, we speak about a figure which is 10 times higher, which is the Google search engine case. If we look at the perspective of those figures against the background of national budgets, these are figures that date back a few years, and they take as the last account the one of the first Google fines, which was 2.4 billion, which was the 2017 fine. Then the figure of 4.3 billion now bypasses the annual budget of the Netherlands and is halfway through to the annual budget of Spain. So these are figures that, taken alone, it's difficult to understand them, but taking against the background of national budgets of EU member states, we see that the fines imposed on a single company bypass the figures for annual budgets for most of the European Union member states. So this shows, just to understand the complexity of the economic impact and the economic considerations that are being taken into account. The judicial review of the Commission's decision regarding anti-competitive practices is twofold. Of course, the direct action is before the General Court as the entry point for the judicial review. But what we do, we look at 2 parts of the what we call the debate. First, we look at the legality of the decision itself. Here, the review is limited because we look only as to whether the decision is legal or not. We cannot adopt a new decision in the case. However, when it comes to the fines imposed on the applicant, we have unlimited jurisdiction. That means that we open the books and we look at the figures, and we may see and we may revise the figures in every possible direction. That, of course, brings me to the essence of our debate. And here I will also have to go back to the classical case law to put things in the context. What is the burden and standard of proof for cases of anti-competitive practices? You may remember that since mid-90s, the Commission has changed its approach towards anti-competitive practices and has started developing a very elaborate set of soft law rules to make rules clear and predictable, previsible, because that, of course, makes a major impact on the quality of the decision, on the quality of procedure, and on the subsequent quality of judicial review. The basic document that we have here as of today are the guidelines for the Commission enforcement priorities that everyone may know. What is important to keep in mind that on 27th March this year, the Commission has announced that it intends to revise those guidelines in order to take into account the recent case law of the Union Courts. So we will have to see how these guidelines are adjusted. I personally do not expect major overhaul of those guidelines, but of course, it is very welcome that the Commission reviews its household and looks at what can be improved. Another important introduction or development since mid-90s, the reality of things as we see them today, is that the Commission has adopted the facts-based approach that, of course, brings into picture complex economic analysis of the facts of the case. These changes have affected the ways and the types of evidence the Commission nowadays is using to prove the competition law infringements. These evidence go into the depth of economic analysis, and of course, it becomes more and more, it becomes increasingly difficult for judges to understand the essence of what is being put before us. Again, what is important when we speak about the burden and standard of proof implied for the Commission is that, first of all, that the Commission is expected to produce a firm, precise, and consistent body of evidence. That means that we're looking at the multitude of various evidences, documentary evidences, economic evidences, classic evidences like witness statements, correspondence. This all has to come into a consistent picture. We rarely take one piece of evidence and go around it. One may be more decisive than the other, but we always look at the global picture, which again requires a very complex analysis, very complex hearings, and very complex, very well organized written pleadings between the parties, very focused approach, because otherwise we're losing time and we're losing focus on what is important in the case. And this is, for judicial review, focus on what is essential for the control of the decision is really the key. This I can say from the perspective of a judge. What is important, and this is what we recently have said in the Intel case, is it is not necessary that every item of evidence, every piece of evidence produced by the Commission satisfies every criteria mentioned above, that every piece of evidence is firm, precise, and consistent. Some of the evidences may be partially inconsistent, some of them could be slightly vague. But what is important is that taken as a whole, this evidence gives a clear and confirming or convincing picture. What is important is that evidence must be credible. And this is where we as a court are being very strict, that credibility of evidence is the key. And as you have seen from the recent case law, we have looked at the credibility and consistency of evidences, regardless of how wide is the margin of appreciation for the Commission, and regardless of the complexity of the case, because of course, the more complex is the case, the more difficult it becomes to look at every piece of evidence. But the effectiveness of judicial control implies that we do the job. What is important as a standard of proof for the Commission is that it does not have to adduce evidence beyond reasonable doubt. What is important is that any doubt that there is, and this is the rule that we have, that in case of doubt, that doubt benefits the undertaking. But of course, then we'll look at every situation, where do we put the weight of the analysis? Whether we put the weight on the presumption or we put the weight on the doubt. But what is important that in case of every doubt, the defending party, in that particular case, the undertaking, has sufficient right to defend oneself. And this cannot be forgotten. And this we go into the substance of interplay between the substantive and procedural rules, because this is where the procedural rules take a very important place in examining the substance. They cannot be ignored. Why am I saying this? Because this is where the intervention of the court is particularly important. What cannot be forgotten, and this is also the case of many of the national competition authority, that the authority that verifies the facts and checks the evidence is the same authority that takes a decision, a sanctioning decision. So there is certain, I dare to say, there is certain conflict of interest, internal, inherent conflict of interest within that authority, because it's very difficult to distance oneself from the long investigative stage of the proceedings when taking the sanctioning decision. There are various methods how competition authorities try to minimize that risk. But of course, that risk might still be there. It is an inherent risk, which is an objective. That comes with the procedure. But this is where it is important for the court to step in and to ensure the efficient review and control of the compliance of the right of defense because of that inherent contradiction. How did we look at those standards of proof and credibility of evidence in the recent case law? In the air freight cases, there was an issue of a certain ambiguity in supporting evidences vis-a-vis the Commission's reasoning. And this is the main job that we do. We look at the reasoning of the contested decision, and literally one by one, we look at the reasons, we look at what are the most important reasons, and then we look at how far the documents of the case file support each and every reasoning given by the Commission. The weak or absent evidence implies necessarily that we exclude that part of the reasoning from the contested decision, and then we see what is the leftover of the reasoning, whether that leftover of the reasoning is still sufficient to maintain the decision in force. In Unilever case, this is very recent decision of this year, the Court of Justice has highlighted that when it comes to complex economic assessment, which is eventually rejected by the National Competition Authority, the National Competition Authority must state out reasons why it considers that the study in question does not contribute to demonstrating that the practices were capable of proving that there was no anti-competitive behavior. The same obligation, by the way, applies vis-a-vis the Commission. So you see the alignment of the procedural rules applicable to the national authorities and the Commission. Again, when it comes to the presumptions are there, that presumptions are rebuttable, and this is the well-established case law, and we see no need to change it. We confirm it from time to time. The standard of proof for undertaking. Well, this standard is slightly different, and you see this is twofold. It very much depends on the way the contested decision is reasoned. So when the contested decision is reasoned but based on assumptions, then what is sufficient to rebut is to provide a plausible explanation. However, when the contested decision is based on concrete evidence, on concrete and credible evidence, then the threshold for proving to rebut that presumption calls for production of the equally important, equally credible evidence to make us conclude to the contrary. What is important for the applicant is again, what we say, to produce evidence at the judicial stage of proceedings, because of course there is a dialogue before the administrative authority, which in our case would be the Commission, but the applicant is allowed, and you may know that the procedural rules are very strict. We have very limited possibilities for the applicants to produce new evidence before the court. We expect under normal administrative procedures that all evidence is already in the file during the administrative proceedings. However, the competition cases are different. This is where we give more room for the applicants to produce new evidence before us, but of course we circumscribe that right into certain framework. We allow the production for new evidence for procedural economy reasons, because sometimes the applicants submit new evidence and we see that this evidence would be the same as we would have requested in any case, so we allow for that. The Commission is entitled to bring new evidence before our court in relation to the facts and reasonings already communicated to the applicant during the administrative proceedings. So it cannot be brand new, but it has to be closely linked to the reasoning of the decision. The evidence submitted for the first time by the applicant in the rebuttal may be allowed. This has been done if this new evidence is essential to rebut the arguments provided by the defending party, by the Commission, in the written pleadings. And the court may ask the parties to explicitly submit new documents, either by means of measures of organization of procedure. These are questions that we kindly ask the parties, or measures of inquiry. This is where we instruct the parties to give us access to certain information. And we can do it with respect to a particular document, or we can go as far as requesting the entire administrative file if we consider it necessary. What is important to remember in terms of challenging the decision is that we have very strict rules of equality of arms, and we do not go and gather evidence ex officio unless, and we do not look at the claims ex officio with one exception, and that is obligation to state reason. This is the only element of the case, obligation to state reason, where we can take the initiative, because this is the classic approach. We consider that if we cannot understand the reasons behind the decision, we cannot exercise our judicial control. Otherwise, we look at the argument strictly in the light of what has been requested by the applicant. And this, of course, sometimes limit our look at the case, because we may see things, but we are not allowed to touch upon certain aspects if the applicant doesn't want us to look, or he has simply forgotten to do so. How we can annul the judgment? We annul the decision. And here is very close link to the economic analysis. We have 4 classical grounds for annulment, which is lack of competence, infringement of procedural requirements, infringement of the treaty, or misuse of powers. We cannot substitute the reasoning of the Commission without proper reasoning. And this is where is the risk of economic analysis and possible expert witnesses. That expert witnesses may bring new information that would be borderline when, if taken on board, the judge will have to propose a new reason for the case, for the decision. And this is the risk that must be avoided. And this is how we look at the situation when we see that complex economic analysis shows the contradiction and the certain weaknesses in the contested decision. This, for us, is a signal that we annul the decision, because if we start replacing the reasoning, then we will go beyond our essential mandate. When it comes to the fines, we do not have that limitation. We can go in all of the directions. What is important that a revision, a variation, as we call it, of the fine is not conditioned on the annulment of the decision. We can leave the decision in force, but still change the amount of the fine. Again, this is an important tool for the judge. What is important for the standard of review? That our center of gravity is on the elements of the infringement and less on the economic assessment. What we did in the recent Intel case, I will show you 3 cases in the time that is left. Of course, one of the central elements that we have in the recent case law, this is the so-called AEC test, as efficient competitor test, that becomes a more and more important test, but this test is economic in nature. In Intel, there was a debate, and you see the case already has a long beard. The judicial control started in 2009. The decision dates back to a few years before that. Here, the debate was first whether the AEC test as such and loyalty rebates as such can be seen as anti-competitive. And first we said that yes, as such, and this is the reason why the first judgment confirmed the decision. But there the court gave, upon appeal, a very important contribution by saying as such, loyalty rebates cannot be presumed as being anti-competitive. So one must look into the substance of the case. And this obligation to look into the substance of those loyalty rebates then really throws the judges into the whirlpool of economic analysis. And in Intel adjudication, I was sitting on the case, we had to hear 2 world-renowned economists, one pleading on behalf of the European Commission and another one pleading on behalf of the applicants. And the extent of that economic analysis was beyond possible comprehension by the judges. But the only thing that we could deduce from that debate is that there are 2 possible plausible explanations to the situation. And this is why we decided to qualify the analysis. And we have considered that some of the rebates and some of the evidence adduced by the Commission was not convincing enough because the test is not as simple as the Commission has presented. So we annul the decision, but the Commission has appealed on points of law. So we have to see whether the court confirms the judgment. In Qualcomm decision, this was the case where we have fully annulled the contested decision based on the violation of rights of defense and based on the assessment of the reasoning of the decision. And what is important in the Qualcomm case that we have looked again into the way the Commission conducted the proceedings, into the way the Commission recorded all the evidence gathered regarding the anti-competitive practices and how this evidence was then put to the applicant and how the applicant was allowed to rebut that evidence. What is important in this case that we also looked at the substance of the decision, and of course we looked, yes, the essence of this was the incentive payments made by Qualcomm to Apple to make sure that Apple uses its product. But what we looked also in this particular case, because we're speaking about the high-tech sector, we were looking also at the fact whether alternatives, of course incentives is something that leads to certain choices. But this is not the only factor that we looked at. We also looked at the fact whether there are alternatives on the market available to use other products. And this has also become an essential point in our reasoning as the Commission could not reply to the question whether there have been alternatives, and Qualcomm has managed to adduce evidence saying that there were no such alternatives, and we decided that the Commission's decision lacked reasons. In the most recent judgment, in the search engine judgments, what is important about the Qualcomm judgment, the Commission has not appealed against the decision, so that against the judgment, so that judgment is in force. In the Google, in the search engine decision, again, the two essential elements for annulment, partial annulment of the decision, of the contested decision, was again the economic analysis, the very same AEC test, where we had to look at the evidence used by the European Commission when making that very complex economic analysis. And again, the second, right of defense, what is the consistency between the statement of reasons and the final decision. So the evolution of the initial investigation versus the final decision, and how efficient was the possibility for the for the Google to defend itself, to provide the rebutting evidence. However, the fact that the rights of defense, and there were certain other irregularities such as the assessment of AEC test, were concluded. This was the case where we decided to leave the Commission's decision in force, but the amount of the fine was reduced. So this was an important example of what was done. And that decision the judgment has been appealed, and the appeal is pending before the Court of Justice. So why have I raised, to conclude, why have I raised all these points? Is to draw your attention that not only the substantive practices, not only substantive case law of the courts of European Union is important, but also the procedural case law. Because if we look at the current statistics of the antitrust cases of the European Union, we see in recent years that national authorities take the heaviest burden, they take the heaviest toll in terms of number of cases being looked at. That, of course, leads to the importance of making sure that the procedures applied by the national competition authorities are no less efficient and no less fair than the procedures applied by the European Commission, because the procedural law is still the same. We're all applying the European Union law. What we see in the research, in the background, in the debate is it is better said than done, it is easier said than done, that there are certain divergences among the national authorities in terms of who can impose the fine, how fines can be imposed, how much of a fine can be imposed, and how much of a judicial review member states offer. Of course, this brings into play the directive of 2019, but the directive of 2019, the central point of the 2019 directive is to give the national competition authorities the procedural tools to deal with the case, to sanction the anti-competitive practice. Where the directive 2019 is slightly short of is to give an elaborate definition of the right of defense. It contains an umbrella provision of the importance of the right to defend oneself and the importance of the effective judicial protection, but there are no further procedural rules. So those procedural rules, I would dare to say, stem from the case law of the European Union courts, and this is important to remember. And my main but concluding remark would be that when member state competition authorities apply their own national rules, what is important to remember, in addition to the fact that they apply complex economic analysis, is to also look that the procedural rules that are being applicable fulfill the criteria of effectiveness and uniform application of the European Union law. Because, as I said, European Union law consists of two arms. It has the substantive arm and the procedural arm. And the national rules should not fall below the average threshold of what the European Union law provides. And this is also the invitation for the judicial authorities for the judicial review at the national level. And of course, that brings me to the main reminder, as I do it every time that I speak, for the especially addressed to the national competition authorities, to the parties to the case, and to the judges themselves, is to remember, especially in case of Latvia, what has been a long-standing jurisprudence and Maxima case. The very fact that we're looking at the national situation does not preclude the application of the EU law, and that means you should not forget about the possibility to ask preliminary questions to the European Court of Justice. Thank you.
Thank you very much, Ms. Reine. I believe your presentation brought a lot of very important aspects, actually several layers of thoughts for us all. But now I would like to invite Mr. Vitaly Pruzhansky, doctor and partner of RBB Economics, with a presentation about Digital Market Act and the role of economics in its application. Dr. Pruzhansky, the floor is yours, please.
Good morning, well, actually, good afternoon, everybody. And first of all, I would like to thank the organizers for inviting me to speak at this conference again. It's a pleasure to be here, same as last year. And I would also like to thank Ms. Reine for her comments about the importance of economics. And being an economist, I was very pleased to hear that. It's been music to my ears. And to continue with this topic, to continue with this subject, I would like to talk about the Digital Markets Act and the role of economics in the application of this act. Now, I believe you can all see my presentation at the moment.
Yes, we do see it.
Yeah, okay. Well, very good. Well, before sharing my perspective on this topic, I think it would be useful to say a few words about about the main idea underpinning the Digital Markets Act. As most of you know, in recent years, the European Commission has been involved in several high-profile investigations against tech companies, and these were pretty long and complex inquiries. Some of these decisions are still being contested in courts. And I think there was a general feeling among competition officials that enforcement simply takes too long, and the market situation may change drastically during this time. And there was this feeling that there's a need for a tool that would allow for fast intervention. And I think this is how the idea about the Digital Markets Act was born. And this act essentially represents a set of rules or obligations on tech companies, pretty much in the spirit of industry regulation like we see in telecoms or in energy sector. It's like a shortcut, essentially, that allows to influence the conduct of some firms without getting bogged down in the details of a regular competition case. And what is interesting is that some commentators said that as long as this is a regulatory act, and as long as the rules of the rules of regulation and the obligations are clear, you do not need any economics. And being an economist, unsurprisingly, I disagree with this position, and let me explain why. Just by way of introduction, let's recall the basics of the DMA and its stated policy goals. Essentially, there are two general concerns in the DMA. It's the risk of unfair practices, and there's a concern about weak market contestability. For those who are not familiar with this terminology, contestability essentially means that entry into the market is relatively easy. and there are no significant barriers to entry which would protect incumbents or insulate incumbents from potential competition. So there are these two very general concerns, and they are legitimate concerns. And in principle, you could say, well, these concerns are relevant for any market, not necessarily for the digital sector. However, because the digital sector is something very important and definitely will be even more important in the future, and because of some specific features of the digital sector, such as extreme scale economies, multi-sided nature, network effects, some behavioral biases, etc., etc., these concerns are even more relevant. And the other reason why the Commission, I think, was concerned about this is that in the digital sector, they see very large undertakings, potentially very powerful undertakings which have a lot of economic power, and these undertakings may behave as some sort of gatekeepers to business users and end users which try to interact with the help of these digital firms, and therefore there was some need for regulation. Now, the key question when you want to do regulation is whom to regulate. How do you define where regulation actually applies? And for this, the Digital Market Act describes the procedure of designation. So how do you designate gatekeepers? There is a definition which is given in Article 3.1, which basically says that a gatekeeper is a company which has a significant impact on the internal market. It provides certain platform services. It enjoys entrenched and durable position in the market, or may enjoy such position in the future. So as far as the definition is concerned, things are more or less clear. Now, what is really interesting is that there are presumptions. Presumptions play a key role in determining whether a particular company is a gatekeeper or not. And these presumptions are linked to the size of the company, like its market capitalization or turnover, the number of users it serves, and whether these thresholds were met in previous 3 years. I think this essentially is where some of the commentators say, well, we don't need any economics, because these presumptions seem to be very, very, very clear, very straightforward. And you just go in and check the turnover, and if it exceeds the threshold, basically this is it. And in addition, the striking feature of this approach is that other arguments or other things which are not listed in Article 3.2 apparently seem to have a very limited role. And this becomes particularly clear when you read Recital 23. Recital 23 essentially says that you can challenge these presumptions, but that is really an exceptional case. You need to have exceptional circumstances in order to ignore them, and that some economic argumentation about market definition or about efficiencies, which I guess we all agree very important topics, in fact should be discarded because it is irrelevant to the question of designation of gatekeepers. And at first glance, it seems, well, there's really not much scope for economics then. And presumably, this is why some commentators say we don't have, economics doesn't really have a role to play. Now, this approach, as such, is likely to be problematic because as long as you deal with presumptions, you always run into the risk of either under-enforcement or over-enforcement. It's very easy to imagine situations where there is some potentially problematic conduct that is not captured by the rules, or maybe some pro-competitive conduct, or let's say neutral conduct from the perspective of competition, which is prohibited. So as long as you have these very strict rules, you immediately become inflexible in terms of applying them, and therefore your enforcement isn't necessarily optimal. And I think this reminds me this distinction between the form-based approach and the effects-based approach that we had many years ago. And I think the conclusion overall was that it is clear what the optimal rule should be. You should look at the effects, not at the form. And it's in a way striking that now we're sort of going perhaps a little bit more towards the form-based approach if you read the DMA. A useful analogy to have in mind is cartels. We prohibit cartels because the effects are almost always harmful. That's why it makes sense to have a rule saying that this is essentially a per se problem. However, when it comes to digital markets, when it comes to the digital sector, many types of prohibited conduct, in fact, may be beneficial or may be competition neutral. So things are not as clear-cut as in cartels. That's why you have to be quite careful with these presumptions. But anyway, this is what is written in the DMA. I think we have to accept that. But even in this case, even if you just stay with presumptions, I think economics still has a role to play when it comes to conceptual issues or measurement issues. For instance, you have to focus on those instances where a company provides core platform services. But what is core platform service? In principle, we need to be talking about a service which represents a multi-sided platform, which allows users, let's say business users and end users to interact in some way. But if that is the case, then there's going to be some network effects. And the question is, is it really strong? Is it really a two-sided platform? How do you deal with purely one-sided services? Let's say a pure B2B service such as some cloud computing. Does this fall into this category? Do we have to worry about these things? So I think there is some economic assessment would be required to answer this question. Then you have lots of measurement issues. What if a company is privately owned? So there is no data on its capitalization. And you need some substitute for that. Again, some economic assessment will be warranted. Then there is a discussion about the number of users. Conceptually, it seems very simple. You have to count the users, you know who the users are, so you can easily count them. But in practice, this is far from clear. Many of the tech companies right now are actually scratching their heads trying to figure out how you count the users, because maybe you have duplicate accounts, maybe you have to make a distinction between logged users versus not logged users, maybe you do not even count users, you count sessions or count something else. So it's not that simple, it's not that straightforward, and again, this is where help of economists will be very important. And finally, there is an interesting question of what happens when some of the thresholds are satisfied, but some are not. What do you do in this case? Presumably, you need to have a discussion about whether some of the thresholds are more relevant than others. And again, some economics will be important. Now, what if some of the thresholds are not met? Doesn't necessarily mean that the company doesn't have any obligations, that the company is not designated as a gatekeeper. Actually not. The DMA is quite clear about this, that even if a company does not meet all the thresholds, it may still be designated. But in that case, you will need to do a full-blown assessment. And the DMA actually is quite explicit about that. So you need to look at the scale and scope effects. You'll need to look at network effects. You'll need to consider whether there are some data-driven advantages, whether there are some behavioral biases which, for instance, prevent users from switching. You will definitely need to look at how users interact with the service in question, whether there is multi-homing, for instance. You will have to look at the conglomerate effects or vertical effects, where maybe you need to worry about cross-subsidization or combination of data from different sources. So again, all these issues will definitely become important for companies where, for which some thresholds are met and some are not. And finally, I think we need to also look beyond the process of designation. Why is this relevant? Well, the DMA imposes some obligations on gatekeepers. So once you designate a company, it will have to fulfill certain obligations. But the market situation may change. After all, we're talking about digital markets which are very dynamic, where changes may happen very quickly, and therefore there is Article 12, which says that you have to update obligations. For instance, you may consider adding more services for which obligations will be applied, or maybe you exclude some of the services. And to do all that, the Commission will have to do a market investigation. This could be done on the Commission's own initiative, or maybe following a request from a member state. And there you will have to essentially do an assessment from scratch. You will have to see whether a certain practice, a certain new service limits contestability, or whether it is considered unfair in some way. And in order to answer all these questions, you will have to have a very clear theory of harm, which will have to explain whether this is a core platform service, whether there are economies of scale, whether there are network effects, essentially to go through all these things that we already discussed. So I guess once you look beyond the simple process of designation and consider what will happen in the future, then economics certainly as relevant as ever. So in conclusion, I would say, even though the DMA represents a certain shortcut for regulation, and even though it is based on presumptions which may not be ideal, but this is what it is, there are still so many economic issues to consider. There are so many economic questions to answer that definitely economists will be very useful in this process. And I think I would like to stop here in the interest of time, but would be very happy to respond to questions.
Thank you very much, Dr. Prużanski, for your very interesting and detailed presentation. I think one thing which I would like to keep in mind is that, speaking about competition law, is that economics is as relevant as ever. I think it should be carved in stone, I believe, in every building, and also in the thinking of every person dealing with competition law. Thank you very much. But now I would like to give the floor to Mr. Andris Rimša, with the final presentation of this part of conference about competition law and the great global decoupling. Mr. Rimša, the floor is yours, please.
Hello, good afternoon, everyone, and let me say thanks to the organizers and all attendees for taking their time and explore recent competition law issues and developments, and there are quite a few of those, as we already seen in the first part of the conference today. And what I would like to cover, and I hope you can see my screen now in the presentation mode, is the trends that we see in the enforcement of competition law globally, including in Europe, and they are increasingly driven by also politics, obviously, and some of the geopolitical developments. And we have already seen some features of these developments that are having some real life impact on the way the competition law is enforced, and we are seeing some potential issues and future problems that may arise as well. And maybe to start the presentation, it's good to take stock and go back a few years, and it is in 2019 when at least that in European competition law, one of the main cases that were handled at the time was the Siemens-Alstom merger between the French and German train manufacturers, and it was a highly also political case. It was supported that potential merger was supported by the French and German governments. It was ultimately prohibited by the European Commission. And after that prohibition decision, the French and German governments came up and issued what they called a manifesto to, in a way, encourage the reform of competition law and to take into account also the industrial policy objectives, including the fact that very often competition takes place on a global scale, and the reason why they followed up on this basis was because one of the key questions during the merger control proceedings between the French and German train companies was whether Chinese fast-speed train makers exert significant competition pressure on the European producers, and the Commission ultimately discounted the entry of Chinese train makers in the European market, which is one of the main reasons why the deal was prohibited. So 4 years ago, the major powers of Europe are encouraging to take an extremely global view on the way how market works. So now, in 4 years, the world has changed on all dimensions, and it was just this week on Monday when the president of the European Central Bank issued what seems to be one of the starkest warnings from a high European policy maker, flagging what the European Central Bank at least is seeing a fragmentation of the global economy into competing blocks, and that would be centered potentially around United States and China. And one of the conclusions that the European Central Bank concludes from this is that it could have far-reaching implications across many domains of policy making, and competition law clearly will be one as well. So we have seen quite stark evolution from 4 years ago when the world was, as many people thought, flat, global, to the situation today where we are seeing increasing fragmentation. There's not so much talk about Chinese competition and Chinese suppliers exercising competitive constraint in Europe anymore. So, and what the impact will be, and we're seeing impact already today. There are some jurisdictions outside the European Union that use competition law enforcement as a tool of industrial policy, and they do that very openly. There was recently an article also in the Wall Street Journal about Chinese competition authority in effect weaponizing its merger control regime. What we are seeing in practice in many cases involving particularly US-based companies, it takes a very, very long time for the Chinese authorities to review these deals. It sometimes takes up to a year or even more to submit a fully completed notification form that is viewed as such by the Chinese authorities. So it is a very, very long time for the merger and acquisition process if it just takes a year simply to start the administrative procedure of reviewing the deal, which may very, very often last for another year or two, meaning that some of these mergers may have to be reviewed by the authorities for 2 and 3 years in the end. So clearly there is a pattern where competition law is used in this geopolitical battle. And obviously, the Baltics and Eastern Europe is very much at the forefront of that as well. We are seeing that authorities in Eastern Europe, competition authorities in Eastern Europe, and particularly Ukrainian competition authority, is increasingly becoming very sensitive not only to traditional competition law considerations when reviewing the deals or applying competition laws, but they're also looking at factoring in other policy considerations, including geopolitical considerations, and understandably, in the case of Ukraine, the Ukrainian authorities are extremely sensitive to the transactions that involve Belarusian or Russian entities, and very often they factor this this context into their competition law proceedings, which have not necessarily, to our knowledge, resulted in distorted outcome of cases, but clearly we can see that there are geopolitical considerations that are becoming an important factor in competition law enforcement, and this may be the case in other jurisdictions as well that are sensitive to the decoupling that we are seeing also in Europe in the context of Russia's war against Ukraine. And this is not necessarily a new debate, a new issue. We have seen this being discussed since the enactment of competition law, also at the EU level, particularly in the context of merger control. The politicians have obviously been tempted towards exercising certain influence over pending matters. So far, at least in Europe, the European Commission has been relatively successful in isolating itself from those political pressures, but clearly there's been quite a few cases where it has not been that easy for the authority, even an EU authority, to apply competition law in an objective manner. And the Commission has sometimes gone at great lengths trying to decouple the pure competition law analysis in its cases from objectives or concerns that may arise from other policy areas of the European Union. There's very often there's a discussion about whether a certain transaction is good for privacy or not, or maybe whether it's good for consumer protection or environmental or climate protection. Bayer-Monsanto merger a few years ago was a unique case as well, where the Commission, in fact, in its decision analyzing the transaction on competition law grounds, had to include a standalone section that was dealing with non-competition concerns, where the Commission very effectively and based on legal arguments made the point that, well, to the extent there may be concerns based on other EU law instruments, the EU competition law proceedings are not the right forum for their assessment. So the Commission has done really effective job in being very transparent about the way it applies competition law, and which as a result has significantly increased legal certainty for all the stakeholders involved. That said, obviously geopolitical concerns, and particularly in the Baltics and Eastern Europe, are real. So there is pressure and objective need to find legal instruments for accommodating these concerns. And since we are jurisdictions that are based on rule of law, we probably do not have the luxury of some other foreign jurisdictions that may simply mix and match different policy objectives in their administrative proceedings, because there is no effective judicial review in many of those jurisdictions in any event. So what the rule of law jurisdictions do in these cases, they just create more law. And that is what we are seeing over the last few years. There is a mushrooming of new regimes that to a large extent resemble competition law enforcement regimes, but that have very different, not and at times very different policy objectives. And there are at least 2-3 that are worth mentioning. One is the increasing adoption of foreign investment review, particularly in the European Union and by EU member states. Another recent enactment of a new regime at the EU level is the foreign subsidies regulation. That will also add additional complexity to a number of transactions that will have to be reviewed on different grounds, and then that is all happening in the background of obviously expanded sanctions and trade rules in the light of the geopolitical events, particularly those sanctions that are targeted against Russia. And maybe just to briefly touch upon the foreign direct investment review regimes, these are particularly have become popular in Europe. Almost all EU member states have now adopted FDI regimes, and very often they, in terms of their structure, they are similar to merger control and the merger control that we can see in the traditional competition law enforcement. But the key difference is that they have, of course, a very different objective. They review transactions on national security or industrial policy grounds, and there's also very little harmony between these regimes. If merger control is enforced also at the EU level, and there's one-stop shop, which is the European Commission for larger transactions, then in relation to foreign investment review, there's no EU authority has jurisdiction to review these, and these are very often national regimes that are supervised to some extent by the European Commission. And they have been proliferating not only in Europe but also in other jurisdictions as well. An increasing number of transactions fall within the purview of foreign investment review. As practitioners, we are seeing that foreign investment review is becoming as important when assessing the deal and timeline risk as traditional merger control. And Baltic countries have become no exception in this in this area. Latvia and Lithuania have had a foreign investment review for some time. It's obviously still a new developing regime in both of these countries, and Estonian government has adopted it as well early this year, and Estonia will have a foreign direct investment review fully in place in September 2023. So all 3 Baltic countries will be fully equipped to review deals also effectively on geopolitical and other national security grounds, which is very much a welcome development. And it is also welcome for the reason that it will make clear that competition law assessment of these deals will be separated, at least in terms of the institutions involved and in terms of the and also in terms of the objectives from the foreign investment review, which hopefully will preserve legal certainty for the involved stakeholders. And what is interesting, Europe is also seeing an increasing number of transactions that have been prohibited on foreign investment grounds. So we have counted since 2016, 24 transactions have been prohibited in Europe, and most of these have been related to investors from China. So clearly, there is global decoupling, and the initial features of those have become quite real. And another regime that the European Union has recently introduced is the EU Foreign Subsidies Regulation. This has a slightly different angle than foreign investment review. The purpose of this regime is to address competitive distortions that are caused subsidies in the EU internal market. And effectively, what the simple way of maybe describing this is, it is a sort of like a state aid regime, but not addressed to EU member states themselves, but to third countries that are not part of the European Union. That said, this regime is very broad. Assuming the relevant thresholds are met, it may require companies, and not only for non-EU companies, but also European companies, to notify deals, transactions to the European Commission, or participation in public procurement before member states, which would also have to be notified to the European Commission, and European Commission's approval will have to be obtained, assuming the relevant financial thresholds are met. And for example, in case of a transaction, it means that the target EU turnover must be more than €500 million, and the parties have received what are called financial contributions from foreign governments, non-EU governments, in the aggregate amount exceeding €50 million, which may sound a lot, but it is being calculated on a 3-year period, and the concept and definition of financial contribution is very broad, meaning that, let's say, you're a European company that has a favorable tax agreement with an authority in Brazil that gives you the net benefit of more than 15 or 20 million euros a year, and you're doing a deal in the European Union as a EU company yourself, in all likelihood, you will meet the thresholds, and you will need to receive the European Commission approval. This regime will become effective on July 12th, and the notification obligation will kick in as of October 12th later this year. And what is also very interesting about this regime is that, to a large extent, it is built upon the experience of the European Commission in the merger control area. So the proceedings will be, to a large extent, similar, not identical, as we are seeing in merger control. And the Directorate General for Competition of the European Union has huge ambitions in this area, and the plan is to hire additional staff, 150 officials that will be tasked with enforcing this regulation. So there's some good news and bad news in all this story. So the good news is that the Europe seems to have finally awakened up and has become more sensitive to foreign divestments that are either distorting the EU market or that are harmful for the EU national interests. Obviously, the downside of that is the additional red tape that these new regimes will impose. And there will be an increasing risk of opposite outcomes, because the more regimes, legal regimes you have that apply to the same transaction or instance, the higher the risk is that conflicts that may arise between the agencies that are reviewing these deals. And if competition policy is generally deflationary, the objectives of competition law are to reduce prices, to make markets more competitive, to introduce more competition into markets, and as a result to reduce prices due to these competitive pressures, then many of these other regimes, their objectives in effect are quite the opposite. They're inflationary, because imposing trade barriers or prohibiting a deal where one of the parties may be benefiting from cheap subsidies from a Chinese government may, as a result, actually mean higher prices for European consumers. So we can clearly see tension between the different regimes when they will be applied in practice. And there have been some examples where it's almost impossible to resolve these tensions. A recent merger in technology space, we have seen we have seen the issue of the parties being in a position where they have to make an argument in competition law proceedings that would be a good argument for them, and that would be almost like a critical argument for these parties to make in order to receive the relevant merger control approval, that by making this argument, the parties would actually make it almost impossible to receive the relevant regulatory clearances on national security grounds within the EU. And one of the examples that has come up in these cases is, for example, when there are some vertical foreclosure concerns that are addressed, that are assessed under merger control regime. There's very often a question, well, in order for vertical foreclosure concerns to arise, the question is whether there's some other competing alternative suppliers that could offer the same product or service in the market, assuming that the combined business were to foreclose its downstream competitors. And in a merger case context, you would argue that, well, there are some other players that can offer a similar or comparable product. But we have seen in cases where this kind of argument has actually been found objectionable by on national security grounds, because sometimes some of these other competitors are Chinese competitors, and then the government agencies who are reviewing these deals on national security grounds, they're concerned that as a result of the merger, the competition in the market may actually increase, but it may increase to the benefit of Chinese suppliers who as a result may be able to increase their market share in the European Union. And this has been a reason for these authorities raising very, very serious objections up to the point of prohibiting transactions. So we can clearly see examples where the objectives of the different regulatory regimes are colluding, and very often there's since the requirement for approvals is cumulative, you need all the approvals. If you cannot gap this tension, then the deal falls apart, and so we will probably see that more and more in many instances. And another example of these tensions coming to light and affecting day-to-day consumer is the situation of Huawei a couple of years ago, when the U.S. government imposed quite severe restrictions on the U.S. companies, including Google, providing its services and products to Huawei, and clearly that was a policy driven on geopolitical, national security grounds, but ultimately, if one were to look at it from a pure competition law perspective, the consumers ultimately were worse off because they didn't have access to another source of cheap Chinese smartphones, and they had access to those phones, but with a much reduced quality. And here's an example of one of the Latvian telecoms operators who was offering these phones to Latvian consumers, but with a very clear notice that these products do not contain any Google apps or services as a result of the trade fictions. So the bottom line conclusion and also advice is for the authorities to be mindful of the frictions that may be caused by applying different regulatory regimes. And what is very important in these cases is transparency, because the conflicting outcomes will inevitably happen. But what is important is to the extent that is permissible, including on national security grounds, is to be transparent and reason the decisions and educate the public and the businesses as to why certain decisions have been made in the way they are, because then the ultimate outcome will be it will increase the certainty for the business environment, and it will also contribute to transparency for citizens, because we as citizens, we have an interest to ensure that the governments act in our interests and that we understand why the governments are taking certain decisions the way they are. And if there are sometimes trade-offs that I need to buy smartphone for a higher price or with reduced quality due to national security reasons, then clearly the government has an obligation to provide reasons for that decision. So on that note, I think I'll conclude my presentation, and to the extent there are any questions, then happy to cover those. Thank you very much.
Thank you very much, Mr. Rimsha, for a very interesting and very topical, I would say, presentation. Unfortunately, as we are running out of time, out of schedule, I believe we will continue without a coffee break, and with just one question in discussion. And this question, I would like to propose the following. It was basically triggered by a presentation of Dr. Pruzhansky about the importance and relevance of different presumptions in competition law, and including the matters dealing with Digital Market Act. And of course, it goes without saying that the role of various presumptions in the competition law is very important. We do have actually a lot of presumptions, but my question, which I would like to address to you and invite to provide some brief thoughts, is that how do you think? Well, perhaps maybe the role of presumptions in competition law is, I would say, slightly overestimated, and maybe we shall step back from the favoring of presumptions and instead going for more detailed and more in-depth analysis on case-by-case basis. What are your thoughts?
So, Lauris, whom do you want to respond first?
Yes, please.
Okay, well, I would say I'm not against presumptions. I think presumptions do help. It's just that the logic behind having a presumption is it's good when the conduct in question is almost always, let's say, less of harmful effect. That's why we can use a shortcut. So there are obviously instances where such shortcuts are legitimate. And, cartels could be, well, the regular, horizontal price fixing, the classical, cartel case that clearly comes to mind as a good example. But when you deal with more complex topics, and digital markets is definitely a very difficult animal to deal with, and it's much harder conceptually than the simple price fixing. I think here it's sort of more dangerous to rely on presumptions because, little things may actually matter a lot. That would be the short answer from me, but I'll be happy to hear other people's views as well.
Thank you very much, Dr. Pruzhansky. Any other thoughts on this matter?
Yeah, maybe I can just add my 2 cents, including in the context of the DMA. It is indeed a big question as to how ultimately the law will be applied in practice, because the issue very often is not only the fact that it relies to presumptions, but also the fact that it has introduced if not revolutionary, then at least significantly another regime with which we haven't really had that much of experience in applying, including on the regulator side and also on the company or consumer side, and that relates to markets that not only are fast moving, but are also very, very recent. So there's simply not that much empirical experience very often with the way these markets work. So one may say that one should always be careful with using presumptions when adopting a policy and new regulations, but you may want to be particularly careful when doing that in new industries and very fast moving industries, which is the case with the DMA. So the level of danger for these type 1 or type 2 errors, as Vitaly already outlined, is quite high. But it seems that policymakers at the EU level are willing to take that risk. There was very strong political mandate for adopting the DMA. So it seems that is the popular will. But it will be obviously very interesting to see how that will be applied in practice and what will be the ultimate benefit of the regulation.
Okay, thank you very much, Mr. Rimsha. Well, unless there are any other thoughts, I would like to invite Mr. Valentins Chytraus, Director of the Legal Department of the Competition Council of the Republic of Latvia, with a presentation about recent case law on the protection of leniency and settlement documents. Mr. Chytraus, the floor is yours, please.
Thank you very much. Hello, everyone, and thank you for inviting to speak at the conference. I think the conference covers a lot of interesting and topical issues, and I will be now kicking off the third part of the conference and switching gears a little bit to a local, maybe, perspective. I hope that the presentation is visible and you can hear me correctly. Hello? Great. I'll be speaking about a recent ruling by the Senate of the Administrative Senate of the recent ruling of the Administrative Department of the Senate, which clarifies the level and extent of the protection from disclosure of the leniency statements and settlement submissions. As we heard today in the conference, there's a lot of already uncertainty regarding the private enforcement and the extent of private enforcement, and it is also to add to that maybe a legal risk or uncertainty regarding of the evidence which has been voluntarily submitted to the authority. Is also something which might add to hardship, and as the authority, the public enforcement should only achieve what it is aimed to achieve, and should not add to any maybe unnecessary hardship. So the views, just a small disclaimer, the views in the slides in the presentations are the ones of the author and do not represent the official view of the competition authority. But let's go to the first slide. So first I'll give some background information regarding the several important aspects of the modern and effective enforcement of the competition rules. Then the presentation will outline the interplay between the various interests which are at play during that within that enforcement, and then the presentation will conclude with how the Senate has resolved those interests. Leniency statements. So let's start with leniency statement and settlement submissions. That is a part of a necessary and very important part of enforcement, competition enforcement. first of all, leniency statements help to detect and uncover secret illegal anti-competitive conduct. Namely, the most recent and most of the cases, most of the largest cartel cases came to light because of the leniency program. And that is a great tool to, first of all, not only to uncover such anti-competitive behavior, but also to gather evidence. And the aspect of leniency statements is that they are voluntary by their nature, and they are incriminating on part of the undertaking. So the undertaking comes forward voluntarily and incriminates itself. The same can be said, or similar can be said, to the settlement submissions. So we are at the latter. So we are at the end of the procedure, where the authority is deciding on the final outcome of the case, and to speed up the adoption of the final decision and to ensure procedural efficiency. It is possible also to settle with the authority. The settlement submissions also are voluntarily and provide direct incriminating evidence on part of the undertaking, because the undertaking has to agree to all the facts gathered by the authority, and for that, of course, in case of leniency, there's a immunity from fine or reduction of fine. In case of settlement, there's a reduction of the final amount of the fine. That would be from the how the evidence is gathered and what is the part of effective competition enforcement. But then there are also other interests at play, and those are governed by access to file and access to information. If we look at the competition law, all the evidence which is gathered has to be presented to the undertakings which are under investigation. And competition law provides rules on access to file. Also, administrative procedure law provides access to file, and the distinction is that the administrative procedure law applies not only to the procedure at the authority, but also to the procedure during litigation, so in a court. Civil procedure law also allows access to file in private damages cases, where under stipulated rules there is a possibility to ask for the competition authority to disclose information in the case file. The last resort is to use the freedom of information law, which is designed to make the access of the information which is within the at the authority to the general public, and these are the sort of the legal acts which compel the authority to provide case file and provide or parts of case file, and these are possible legal acts to exercise that right. And then we see that there are several interests at play if we try to balance the access to information and the effectiveness of public authority of public enforcement of competition rules. So the primary interest of the authority would be to ensure effectiveness of competition enforcement. Then the accused undertakings, which are under investigation, exercise the right to be heard and right of defense. So they should be provided sufficient access to case file so that they can exercise those rights in a meaningful way. Then the third parties or interests at play are the harmed parties, which have suffered from the competition infringement, either be it in a cartel infringement or abuse of dominance. So there are also rules which say, well, under which circumstances those parties can access information which has been gathered in the case file. And then we come to the general public, which can access information for as a part of transparency, but which is not specific, maybe specifically to competition enforcement, but which relates to any information which is at the any type of information or on a different subject matters within the state administration. And there we see that all those interests come into play if there's sufficient incentive for companies which have been involved in the infringement to come forward and voluntarily submit information, either by uncovering the illegal activity or speeding up the process of resolution. So we see that in case, for example, if there's no leniency or there's too burdensome to exercise the right to leniency, then the authority doesn't find out about the authority and public at large don't find out about the infringement, and harmed parties do not know that they are being harmed, and therefore they cannot start restituting their interests. So we can see that there has to be a balance between the parties which voluntarily incriminate and cooperate with the authority with the interests which are inadvertently affected. And then we come to the ruling of the Senate from last year, where the Senate has weighed in on all those interests within the administrative procedure. Just to give a factual background, the case the case itself is still pending the final outcome, but the ruling of the Senate is final and is not subject to further judicial review, and therefore is already possible to analyze it and already rely on the legal certainty provided by that ruling. So the facts of the case are that the competition authority adopted a finding decision in a Article 101 case, a cartel case, and one of the companies settled with the competition authority, and then did not, as a course of that, did not appeal that decision. And then one of the addressees of the decision challenged the decision, but also in a separate legal action requested that the authority disclose the settlement submission. And the authority declined that request, and that triggered the judicial review, where that Senate decision, the Senate ruling, was adopted. And when the Senate weighed in on the interests at play, they looked at the EU damages directive and how it's being transposed in the Latvian civil procedure law. And the Senate recognized that there is a link, an inherent link between the voluntary cooperation and the rules on how that voluntary cooperation or information which is gathered through that voluntary cooperation is being further disclosed. And therefore, looking at the regulation and of the damages directive, recognizing that leniency program and settlement procedures are important tools of public enforcement, and that undertakings might be deterred to cooperate with the competition authority under either leniency or settlement procedures. They might be deterred if that self-incriminating information becomes disclosed to either in the private damages actions or to the public in general, and therefore to balance that risk, the leniency statements and settlement submissions are exempted from disclosure. And the lower court in this case was was not allowed or was not was prevented to apply administrative procedure in isolation, because those considerations which are in EU damages directive and civil procedure law, they are based on the civil procedure and on the practice of the private litigation. But those rules are not directly stipulated and in the administrative procedure law. So the Senate took the considerations which are in the civil procedure, which are made in civil procedure, and applied them to the administrative procedure. And just to illustrate why and explain those considerations, the Senate sort of gave some examples of how such maybe unwarranted disclosure of either settlement submissions or leniency statements might have an effect on the companies who voluntarily cooperate with the authority. Sort of the Senate gave somewhat an empathetic view of what the companies might experience when they voluntarily cooperate, and then that becomes it has to be disclosed. So even disclosure which is unwarranted, and by meaning unwarranted is something which legally can be reversed in future, in factual terms does not help too much, because disclosure of such confidential information instantly places cooperating party at a disadvantage, and because the fact of the disclosure is something that is irreversible, you cannot erase the memory of disclosure, and even if you seek some kind of compensation for unwarranted disclosure, you cannot you cannot how to say put the toothpaste back into the tube. So it's spilled into the public domain or to the parties which are not entitled to such information, and there's little you can do to reverse that. So and the court also gives some example, for example, for the disadvantage which the company might incur in cases of joint and several liability, and also just in general reputational risks. So application of administrative procedure in isolation from the civil procedure law and from the interests which are stipulated in the EU damages directive and then transposed into the national civil procedure law ignores those risks and therefore have to be observed. And that's only if we look at the unwarranted disclosure in case of private enforcement. It has also a spillover effect to the administrative procedure. Foremost, it chills the incentive to cooperate voluntarily. If the company knows that there's either no legal certainty or there's a great risk that those statements become public, then you would think twice to cooperate with the authority, and that in effect lowers the effectiveness of enforcement. And that in effect lowers the detection of the anti-competitive conduct, and as such, it also prolongs the harm which is being caused to the injured parties. So also the injured parties, you would argue that the injured parties or harmed parties, because of their illegal activity, are actually interested in providing sort of a safe harbor from disclosure of information, because that provides for a speedier detection of unlawful activity. And the court also once again clarified between the rights of the private person under Freedom of Information Act and Administrative Procedure Law There is a precedent from 2017 by the Senate, which said that although, for example, a party to the litigation where the competition authority's decision is being disputed realizes its rights to access to file, and for example, if the court in that procedure declines such request to access certain documents in the file, the undertaking might launch a separate procedure under the Freedom of Information Act, because it may not be prevented to pursue maybe some specific avenues of right of defense, which may be in the case disputing the Competition Council's decision might not be seen well obvious at that time. But what the Senate clarified in this particular ruling, saying that although, for example, that 2017 ruling applies to the case file and applies to documents which are not part of the case file, it in this case just says that even, for example, if the document is in the case file of the authority but was not handed over to the case file of the court, it still remains the case file of part of the case file, and therefore should be viewed not through the Freedom of Information Act, but rather from the Administrative Procedure Law. So to conclude, the strict rules under the Civil Procedure Law, from the Senate's point of view, guarantee the highest protection from disclosure of leniency statement and settlement submissions. And the Senate rules that you may not apply or evaluate interests which stem from the administrative procedure, for example, from the Freedom of Information Act, without taking into account the rights which are stipulated in the Civil Procedure Law or which stem from the civil procedures. You cannot do that in isolation, and you have to look at that in a holistic way. Because it's what constitutes or what is a part of effective enforcement of competition rules, and the ruling also closes the gap which might for some time was open, that it cements the legal certainty that the documents and the statement and the leniency statement and the settlement submission is which was provided to the authority on a voluntary basis for the purposes of enforcing competition rules and investigating the infringement, are incriminating in their nature, are something which is awarded at the highest confidentiality level, and which are not to be disclosed if in various procedures, except for of course in case of right of defense, but that's a separate issue. The main issue is that this is only those settlement submissions are used for the and leniency statements are used for the enforcement of competition rules, and not to maybe realize other interests, either through private damages or maybe interests which stem from the private or for the public right to information. Thank you very much. If there are any questions, I would be happy to address them. Thank you very much.
Thank you very much, Mr. Chytraus, for your very interesting and clarifying presentation. And now we would like to switch from the online presentations to the presentation in person, and I would like to give a floor to my fellow colleague, lecturer of Faculty of Law, University of Latvia, and also chairwoman of the board of the European Law Association, Ms. Esmeralda Balode-Buraka. Please, the floor is yours.
So I hope you can see my slides. Hello everyone. I'm pleased to be here. I enjoyed the previous discussions a lot. I hope you will enjoy mine as well. And in fact, it somehow reflects the subject which was already tackled today by Honorable Judge Inga Reine. So especially if you heard her presentation, I think then it's going to be as a continuation, natural continuation of her thoughts here. So to the question, is there a national procedural autonomy in the competition law? Of course, I started with artificial intelligence, checking what it says. So by posing a question there, ChatGPT, so is there a national procedural autonomy in competition law? You all can see the answer. So it says yes, there is, and it means that each EU member state has a power to determine the procedural rules subject to certain minimum requirements. So artificial intelligence stresses minimum requirements. I would slightly disagree here. You will see further on why, but at least some answer is here, and I'd say that partially correct. Then next, if I'm asking dear Latvian Competition Council, what's your thought? Is there a national procedural autonomy? We heard an answer in a court a few weeks ago. I'd say this is a recent answer, and the answer was first, regulation number 1 as of 2003 provides the national procedural autonomy. And secondly, the Competition Council investigates on the basis of the national material and procedural law as it's stipulated in the Latvian competition law, section 28, part 1. So the conclusion was, surprisingly, that there is absolute procedural autonomy. And in following further, it was clarified that the Competition Council enjoys the right to refer to the European Commission's practice in some circumstances, but in other circumstances not rely. So in other words, it enjoys absolute discretion in which situations to refer to it or not. So in addition to this statement of absolute procedural autonomy. Quite interesting. And if we turn to the European Court of Justice, we all know this pretty old judgment, Rive Central case, and where the EU court said that procedural autonomy of the EU member states refers to the doctrine that in the absence of the EU law, so first of all, in the absence of the EU law, and member states may design their justice systems in the manner they find appropriate as long as the system renders EU law effective and equivalent protection. Equivalent may be not that often challenged, but this issue of effectiveness is at stake time from time. So this is the status which, and the statement which was given by the EU court nearly more than 40 years ago. Before continuing, I'd like to clarify a bit of scope of the issue I'm talking about. So first of all, it's not merely procedural. We are talking both about procedural issues, so it's rules of evidence, time limitations, etc. So classical procedural matters, either it's administrative or civil procedure. And we are also talking about compensation mechanisms, so repayment rules, damages, claims, amounts of damages, etc. And which is in most situations civil law. And we are also talking about judicial remedies. So first of all, it's not just a procedural issue which is at stake in a very narrow manner. So it's in a quite broad, I'd say. And also, in addition, so the scope of the issue we're talking about is broader than competition law. So the question actually is there a national procedural autonomy at all can we draw some parallels from competition law to other areas or not? What are the differences? So speaking about the procedural autonomy, it's always worth to bear in mind that it's broader than competition law. And here I'd like to mention three cases. One is Latvian preliminary reference in private bank case. A reference from 2018. And the question was, shall the Latvian financial regulator rely on the judgment of an arbitration court? And the answer was yes. The answer, the preliminary ruling of the EU Court of Justice was yes, the national law may provide so, unless the aim of supervision, right to be heard, and other essential elements of the EU law aren't endangered. So, in other words, the principle of effectiveness, and the national court had to check whether the principle of effectiveness isn't endangered in that case. The second case I'd like to mention is also preliminary reference from the Latvian court. It's LS Customs Services. It's a bit older one, and here the question at stake was what's the standard of grounds to be provided in an administrative decision. So it was an administrative procedure, also very interesting case, but as you can see from this one, so it's not just about the competition law, but in this case it was customs law. And the third case I'd like to mention here to illustrate that the issue is broader than competition law, it's Hoffmann-La Roche. It's not Latvian preliminary reference, it's a new Hoffmann-La Roche, it's not the old one. And here the question at stake was what's the national right of the national law to provide that the judgment of the last instance court may not be reopened, even in the situation where later on it turns out that it was wrong from the EU law point of view. So the question was about judicial review of the judgment of the last instance court. So either the national, we can say procedural rules, but here you see that it's far already broader than just mere procedure. So is it acceptable that national laws, of course also Latvian law, provide so? And here's the answer of the EU court was, of course, that national legal systems may do so, because in this particular situation, if it turns out that the EU law was applied incorrectly, so there is a principle of state liability which can be invoked, and still so this damage can be compensated through this additional mechanism, which also stems from the EU law. We come to the next point then. Referring back to the position, long-standing position of the Latvian Competition Council, that there is absolute procedural autonomy, we have to look back to the regulation number 1 of 2003. Most of us have studied during that times, and yes, when the regulation was adopted, basically the concept of absolute or close to absolute procedural autonomy was pretty alive. Of course, observing the principle of effectiveness. But we clearly have to see the difference in between 2003 and 2023. It's 20 years, and this is quite characteristic for the European law, that it develops all the time. You could hear today during the presentation or from the speech from Andris Rimša, for example, where he clearly illustrated how EU law is related, the EU competition law is related to the geopolitical processes. The same about the procedural side of EU law and also of the competition law. So there have been several developments in the domain of regulating, and two of them, so I have to mention two of them. One is Directive 2014-104 on action for damages in competition law. you all are aware also from today's discussion what about it is. Basically, it was a result of the long row of the judgments from the EU Court of Justice. So finally, there was a harmonization. We can, of course, have a long-standing debate, is it sufficient or not, but at least it was some result in the form of harmonization. And we have to take it into account because this directive fulfills one of the gaps where it was previously said it's absence of EU law. Or if there was no absence, we had to follow through the judgments, numerous judgments, consecutive judgments of the EU Court of Justice to see what's the status. So following these judgments, the directive was adopted, and directive sort of comprises the result of the jurisprudence standing at that time, 2014. So what's in there? I just mentioned few of subjects. So first of all, right of full compensation, because it was not the status in all the member states. Disclosure of evidence rules, also limitation periods for bringing actions, etc. And another spot which was fulfilled by the harmonization, so by the European institutions, instead of the EU Court of Justice rulings, it's a more recent directive. It's Directive 2019, number 1, which was mentioned by Honorable Judge Inga Reine as well. And this is directive on more effective enforcement. And just few of the subjects mentioned in there, EU fundamental rights, right to be heard, which was also mentioned today, and as you already heard today, so it's mentioned in the directive, but there are no, let's say, detailed rules. So this gap still has to be fulfilled by the regulators and by the national courts. So this is very, very important area at the moment. Secondly, minimum powers to inspect premises is also harmonized within this directive. Also, it's about effective remedies, choosing the less burdensome for undertaking result, which is also, I find it quite important, quite relevant, because not always there's a feeling that our regulator, competition authority, is choosing the remedies from the point of view which would be the less burdensome for undertaking. I wouldn't say that in all cases, but there are a few cases which brings this doubt in. And then finally, about the current status of the EU law on domain of effective application of this law. So the status is that observing that there are no EU rules, and as we just clarified out, so there are areas where are already EU rules through directives, which are implemented in national laws and hopefully correctly and precisely, then there is still no national authority anymore where it would make the exercise of EU law-based rights impossible or excessively difficult. So once again, this EU law efficiency, effective applicability test, which goes through the application of the possible and not difficult application of the EU law. I have used the term national authority here instead of procedural autonomy, national procedural autonomy. There is also a huge debate, scientific debate behind that, but I'd say that maybe this term national authority instead of national procedural autonomy reflects the current status of this legal concept a bit more precise. So it's not exactly about autonomy, it's more about authority. And as we can see also through the academic researches and also courts jurisprudences, so time from time you can observe that the researchers and also practitioners are switching a bit away from this concept of national procedural autonomy, just calling it a bit more precisely. And few EU court rules on quite recent rules on this on this domain, on national procedural authority. So here I wanted to mention 6 of them very briefly, and not describing the facts of the cases, but so one of them, Courage and Krihan, where this is one of the first cases on damages, and it served as inspiration for damages directive. Then Manfredi, which describes national procedural rules on limitation periods and addresses this issue. Also addresses issue of damages claims for breaches of competition law. Also the possibility to apply for interest in damages cases. Another one, Kohn and others, you heard about this already earlier today. Then another one, Eturas and others, where the presumption of innocence and the inference of knowledge of concerted practices is addressed. Then Skanska, quite recent case, piercing a corporate veil, was lifted to ensure effective damages claims, and also Cogeco case, where national time limits for bringing cartel damages cases was addressed. And concluding on the EU court jurisprudence, I'd like to mention very, very recent judgment from the EU court. It's actually yesterday's judgment. It's Repsol case. And here, just 2 statements from this judgment. It's exactly on my today's subject. So first of all, the court, the European Court of Justice, yesterday says that national procedural authority, here is the word authority, exists under the earlier explained conditions. And these conditions which are explained there are, so in the absence of EU rules, observing the principles of equivalence and effectiveness. So if there are no EU rules, then observing the principles of equivalence and effectiveness, there can be national procedural authority, but it has always been verified. And secondly, what's also said in this judgment, even more important, so if the first, if the previous statement just confirms the status, then the next one says that in particular, the detailed rules referred to the paragraph 58, so the previous one of this present judgment, must not jeopardize the effective application of both EU treaty articles at stake, and must be adapted to the specificities of competition law cases, which require in principle a complex factual and economic analysis. I will not go into more detail into this statement, but I think it brings a lot actually in this particular topic. First of all, it's about the right to be heard, right to defense, etc. So if we look to these issues through the economic analysis perspective, so we might see a bit different picture if we compare it with the status as it was before, at least from the Latvian national regulator's point of view, and also through the national courts jurisprudence point of view. And to conclude, so I'd say that from my point of view, the core of the problem of different views on the national procedural authorities, the core of the issue is that EU law primarily seeks to ensure effective enforcement of selected policies. So it's competition law, it's intellectual property, it's consumer protection, etc. So it's a specific area where the specific level of protection is set. And whereas national law is designed to maintain the coherence of its procedural law, so coherence through all the civil procedural law, coherence through all the administrative procedure law. And here is the core of the problem, so basically it's difference of angles. And what would be the solution? It's quite obvious. I'd say it's case law based rules again. And so the final statement is, I'm happy it's quite close to the statement which was today rendered by Inga Reine, that I brought it from one of the researchers I examined when preparing for this presentation, its publication on Cambridge University Press, and it states again and again that a complete system of judicial enforcement can only be achieved. So here, by saying that complete system of judicial enforcement, so both together, EU court system and national court system, and it can be achieved in the EU by unyielding obligation on member state courts to implement union law. And the bottom line for this would be that as far as individual rights are concerned, the rule of law and the system of judicial enforcement are only as strong as the member states' courts make it. That's it today from my side. Thank you very much.
Thank you very much, Esmeralda. And now I would like again switch from presentations in person to the presentations online, and would like to invite Miss Samantha Lidere.
Hello, I hope you can hear me.
Yes, we do hear you.
I'm
Hello.
trying to share my screen now in a bit.
Okay, yes.
Can you see my screen?
No, unfortunately
Okay.
not yet.
I will try to share it here again. I might have some technical difficulties, unfortunately. I'll try again. If I may, I will connect from a different device so I can share that my screen is shared.
Yes, please.
It will take 1 minute. Thank you. My screen
Yes,
should be
now we do
visible
see
now.
your presentation.
Great, thank you. Sorry about the hiccup.
It's fine. You're welcomed.
So thank you once again. It's my greatest pleasure to be here today and to speak among such distinguished speakers today. And even more, I'm really happy to be able to do so on such a novel topic in the EU competition law framework, which is no-poach agreements in European Union competition law. And today I will try my best to give you an in-depth insight into what no-poach agreements in their substance are, and try to put the no-poach agreement within the current EU competition framework, as well as try to identify the existing and possibly upcoming challenges and current enforcement practice so far. My presentation today will implement the concept of no-poach agreements within the applicable law. So therefore, to kick off the discussion today, it is crucial to acknowledge the substantive ambit of no-poach agreements themselves. So when we speak about no-poach agreements, we can use several terms to refer to such agreements, because these agreements are somewhere in a legal doctrine, also in practice, referred to as non-solicit, no hire, or no cold call agreements. And the legal definition of no-poach agreements cannot really be found in any legal or academic documents, but mostly are to be identified in the practice. And I think it's not loud to say that the United States antitrust agencies have been the global leaders in pursuing enforcement action about competition law distortments in labor markets. And therefore, I think an appropriate starting point definition of a no-poach agreement can be found in the United States Department of Justice Antitrust Division's guidance that was published in 2016, and which defines no-poach agreements as agreements where companies agree to refuse to solicit or hire that other company's employees. And this guidance was largely adopted as a method to try to, in a structural way, to summarize this existing practice of the United States antitrust agencies, which have been pursuing action against no-poach agreements and other distortions in labor markets, such as wage fixing agreements, since even 2010. And the groundbreaking case that kind of, to say, started the discussion about labor market distortions and competition law was the civil action case against the Silicon Valley tech giants, which agreed not to hire each other's software engineers and to make such employment offers conditional upon a previous approval of another party involved. This case was ultimately settled by way of a settlement. However, by publishing this guidance that I am citing here in this slide, the United States antitrust agencies try to set a lesson for companies in the future that from 2016 and on, such agreements will be tried to prosecute as per se violations, and therefore such agreements may fall under the criminal prosecution. While such agreements as no-poach agreements are relatively novel, the United States antitrust agencies practice allows us to draw several hefty conclusions about what no-poach agreements are and how do they materialize. And the way I like to look at no-poach agreements is that no-poach agreements essentially establish a triangular relationship, where at the base of this triangle, the existing and the potential employers, agree to subject the oblivious third party, which is the employee, to his or her labor restrictions. Therefore, in essence, these two parties, or even more parties involved, which are the existing and potential employers, these parties agree to apportion the respective labor among themselves and, in effect, eradicate the competition among themselves. However, a reasonable question might be here, so what essentially is the competition law problem here? Because essentially what we see from no-poach agreements is that the existing and potential employer, in essence, restrict the labor elasticity of the employee in question. So where exactly is the competition law part here if the harm is primarily materializing in a social context? However, the question about where does competition law meets labor market is found in the economic theory underlying no-poach agreements, and which is crucial to be acknowledged with in order to even understand the theory of harm, and thus why such agreements fall under the prohibition established in Article 101, Part 1 TFEU. So the exit point premise to start such effects-based analysis of no-poach agreements is that labor markets by themselves are highly concentrated. And this premise arises from several legal research conducted in United States. However, there is no real and rational reason to believe that the situation in European Union is much different. So what does that mean? It means that in labor market, there are only a few employers who are looking for specifically skilled employees, and therefore the competition by itself is kind of limited. In essence, if you look at no-poach agreements, it is clear that such agreements, in essence, can materialize even better in market circumstances where the market is already characterized by high concentration. Thus, when we start to analyze no-poach agreements, it is clear that, in effect, these agreements generate collusive monopsony. And what is collusive monopsony? I think it is quite handy to look at this concept as a mirror image of the well-known concept of monopoly. So a monopsony is, in essence, the mirror image of monopoly and is a subtype of buyer power, which in this case is exercised by the employers in question. So in essence, what happens when the employers conclude no-poach agreements is that these parties agree to apportion the respective labor among themselves, and in effect limit or even eradicate competition completely, acting as the sole, or how to say, lone buyers of this respective input. And the economics underlying no-poach agreements essentially show that the employers try to find a favorable equilibrium between 3 points, which is the wage, the quantity of labor needed to be employed, as well as the marginal revenue product, which equals labor demand. So monopsonist employer, which enters a no-poach agreement, knowing that he is the sole buyer of this respective labor, since there is an artificially created monopsony in place by way of a no-poach agreement, decides to employ a diminished amount of employees or inputs, if you speak in economical terms, and therefore, in essence, withholds its purchasing power. And this is where competition law concern comes in, because this is a clear indication of allocative inefficiency, which in essence creates deadweight loss. And why is that so? This graph that I have included in this slide, I think kind of clearly reveals that monopsonist employer deciding to employ a diminished quantity of workers, in essence, has not used the production potential that is available in market, and not has cleared the market as it could have if a competitive wage would have been offered. So what does that mean to competition law and the consumer welfare that competition law has adhered to protect? It means that diminished amount of input that has been purchased by the monopsonist employer means that possibly the output may be lowered, the quality of the goods produced downstream may be lowered, and also, of course, there is a risk of dynamic inefficiencies that result due to a lack of competitive pressure on these employers, which have entered a no-poach agreement. So what this slide essentially reveals is that when one is assessing no-poach agreements, there's simply no way to escape the effects-based analysis of such agreements and to conduct an in-depth economic assessment, which largely is quite complex. However, as I mentioned in the previous slide, when we were assessing the substance of no-poach agreements, it comes clear that ostensibly the no-poach agreements primarily hurt the employees as social actors. Thus, employers have decided to limit the labor elasticity of such employees without the consent of such people, and largely also without any knowledge that such agreement is even in place. And this creates a twofold theory of harm, as I would like to call it, where one clearly identifiable harm stems from the collusive monopsony that no-poach agreements have created. And the second theory of harm is largely imposed upon labor, thus workers, as socio-economical actors by way of income inequality, as due to the no-poach agreement, the employers have no incentive to be competitive since the competition is eradicated and complete. And therefore, a reasonable question, or so to say, a challenge comes in, is whether competition law should also respond to the wealth inequality and distributive justice concern that comes in here, and which is in economical graph terms referred here in this yellow rectangle form. So this is one of the main questions that the academia has now identified, whether the scope of EU competition law may indeed be far-reaching and step outside the well-known benchmark of consumer welfare. In today's presentation, I want to try to apply the existing law, which is Article 1011 TFEU, to no-poach agreements. To start off the discussion, it must be first of all noted that the current practice in European Union is quite limited. However, the Commission has, of course, followed the practice of United States antitrust agencies and signaled that labor market distortions may come upon its radar anytime soon. However, since there is not much practice, yet some from national competition authorities, the conclusions made today are largely based on the practice of United States antitrust agencies and are implemented here by way of legal analogy. So the first step to even try to do any assessment regarding no-poach agreements, or let alone any agreements within the EU competition law framework, is the trigger of the concept of effect on trade between member states. The current limited practice on no-poach agreements in European Union may simply be explained due to the fact that labor markets are usually purely local and thus concerned with only one member state. What does this mean is that no-poach agreements may likely only fall within the jurisdiction of national competition authorities rather than trigger European Commission's jurisdiction. However, this is not always the case, as it has been signaled by the Portuguese National Competition Authority in 2021, where the National Competition Authority examined the no-poach agreement within the national law, but also applied Article 1011 TFEU due to the fact that simply the agreement that was implemented in the respective case had the capacity to partition the internal market of the EU, and therefore triggered the application of Article 1011 TFEU. This is also contained in the notice on effect on trade between member states noticed by the Commission that there are several agreements that may even trigger this jurisdictional criteria, even if they are confined to only one member state or only a part of one member state. So simply, this may not be the only explanation why such agreements are yet to come upon the Commission's radar. However, this may be one of the explanations. To move on and assess no-poach agreements within the prohibition laid down in the respective article, a relevant question is whether these agreements would qualify as by-object restrictions or rather fall under the by-effect assessment. The existing practice of the Commission shows that whenever novel types of infringements come into the play, Commission is rather resistant to automatically try to qualify an infringement as a restriction of competition by object. However, the existing practice of national competition authorities, as well as the practice across the Atlantic, shows that these agreements are usually treated as the hardcore restrictions of competition, or as they are called in the US, as per se violations. It is though because these agreements, as I will show in the next slide, show very large similarities with already established hardcore cartel restrictions, and also the underlying economic theory shows that there is indeed not only a limitation of competition, but a complete eradication and removal of competition in the relevant markets. Also, in Canada, the enforcers are now trying to adopt theory of harm to be applied to such agreements, because whenever these labor market infringements came into play in Canada, they were treated under the so-called rule of reason doctrine, which is similar to the by-effect assessment in the European Union. However, very recently, there has been a change in this approach, and also in Canada, these agreements are treated as the per se violations of the respective competition acts. As I mentioned before, no-poach agreements in practice so far have been identified as somehow similar to already well-established hardcore cartel restrictions. Both in the United States as well as the so-called local European Union national competition authorities practice, it can be seen that the authorities try to take, so to say, characteristics that apply to no-poach agreements from both horizontal input purchase price fixing agreement, which is established in Article 101, Part 1, Sub Point A, as well as horizontal market sharing agreement, which is established by way of an example in Article 1011, subpoint C, TFEU. And indeed, if we try to draw some similarities to no-poach agreements from already existing practice of these agreements mentioned here in this slide, we can see that no-poach agreements, keeping in mind the economic theory of harm underlying them, do show large similarities with horizontal market sharing agreement due to the collusive monopsony generated, therefore establishing exclusivity against portions of respective labor that the parties of a no-poach agreement have agreed to apportion among themselves. and therefore eradicating competition for this input by way of offering, for example, better employment conditions or a more competitive wage, as well as the collusive monopsony by way of suppressed purchasing power allows the employees to suppress wages simply due to the fact that they know there is no competitive reaction from the other employers in the market. Moreover, what is interesting here is that the practice in the European Union national competition authorities practice reveals us that no-poach agreements may also create and generate entry barriers in markets, for example, where the success of a market player is highly dependent on well-skilled and knowledgeable staff, as would be the case, for example, in high-tech markets. And this therefore would lead to dynamic inefficiency, stifled innovation, and would even restrict new competitors to come into the market at all. Moreover, no-poach agreements, of course, similarly as horizontal market sharing agreements, allow employers to keep respective labor among themselves and therefore also limit knowledge spillovers, which would be crucial for innovation process in the markets and in general to try to in any way motivate innovation in markets as a whole. So in conclusion, no-poach agreements do share similarities with already existing hardcore restrictions that have been identified and applied in practice. However, of course, this is indeed a novel distortion within the global competition law discourse. And I think it's safe to say that national competition authorities may still come upon many challenges and possible hiccups for argumentation, where parties may try to putting forward efficiency arguments that these no-poach agreements may try to generate. And this leads me to my third step here, is that when we are applying Article 1011 TFEU to any agreement, we must consider whether there are any efficiencies that this agreement may generate. And once again, here I am looking back at the practice of the United States antitrust agencies and the courts, where there have been attempts to try to argue that these no-poach agreements, which have allowed employers to save costs on labor, in general creates a pass-on effect on downstream prices due to the saved labor expenditures and allowing consumers to enjoy a fair share of this so-called generated efficiency. However, in my opinion, and also this is, I think, a reasonable approach to start the argument here, is that there is somehow a paradox here that you cannot really argue an efficiency argument on downstream prices if this so-called efficiency is generated due to the detriment of workers, which, moreover, are consumers, and vice versa in different market situations here. And also, the competition commissioner Vestager has publicly spoke out about labor market distortions, and she has clearly indicated that EU competition policy shall not only protect consumers, but also should be concerned about worker welfare. And right now in the academia, there are some discussions here about the consumer welfare standard and whether it is indeed still an appropriate benchmark for assessment of infringements within the context of EU competition law, or whether we should try to move forward to a more inclusive standard to assess possible anti-competitive distortions here. And one of the suggestions in the academia by Professor Firat Cengiz of University of Liverpool is that there should be a citizen welfare rather, keeping in mind the constitutional embedding of EU competition rules. Since the competition rules, thus Article 101 here, is embedded in the founding treaty. And moreover, EU competition law cannot cherry pick which goals EU has adhered to protect, because EU competition rules shall be implemented and interpreted systematically within the treaty framework here. And for example, Article 8 TFEU requires EU to take into, in all of its enforcement and all of its policies, the eradication of inequality. And Article 9 TFEU, in essence, prescribes that EU should adhere to ensure that there is adequate level of social protection, and that, in essence, workers are protected under the treaty. So, in essence, this means that it will be hard to argue any efficiency arguments generated due to a no-poach agreement if this efficiency is generated to the detriment of workers, even though possibly, but this is quite a hard way to argue, the downstream prices may indeed be lowered. And indeed, this has also been the way of argumentation in many cases in the United States. For example, in the United States versus Davita Inc. and theory case here that I have mentioned here, not only the saved labor expenditures was one of the arguments put forward, but also the protection of employers' investments in employees' training. The no-poach agreements kind of fulfill this protective role of the employers. However, the court was quite strict in this regard, and said that this argument is definitely ill-founded because they are definitely less restrictive measures to achieve the same goal, for example, by way of different incentives such as bonuses, better working conditions, and etc. As I mentioned in the beginning of this presentation here, the enforcement in the European Union has indeed been limited. However, the Commissioner Vestager at late 2021, in her speech at the Italian Antitrust Association, mentioned quite clearly that labor markets are indeed a new era of cartel enforcement also in Europe, and they are no less harmful than traditional cellular cartels. And basically, these conclusions were largely made upon the existing practice of United States antitrust agencies, which the Commission has admitted to follow very closely. And it is expected that in the near future, Commission may even pursue action against no-poach agreements, and we might even receive some guidance upon assessment of no-poach agreements from the central enforcer here in Europe. However, as I mentioned here before, the national competition authorities have already commenced to close the gap in enforcement here in Europe, and the Portuguese NCA has been the definite forerunner in the enforcement within the labor market frameworks. And this competition authority in 2001, in May, if I may recall, published a quite lengthy guidance on labor market distortions and the application of competition law within. And a few days actually after the publication of the guidance, the NCA published a quite lengthy 400-some page-long infringement decision against 31 Portuguese professional football clubs. And in that case, the Portuguese Professional Football League, as a third party, had required its first and second league clubs to implement a no-poach agreement among themselves against employees, thus football players, which had terminated their contracts due to the COVID-19 pandemic. So in essence, these clubs agreed not to hire the football players that had indeed terminated their contracts due to this, due to the COVID-19 pandemic. And what the NCAA found is that, first of all, this is a clear market sharing agreement, as well as indirect way to lower the input purchase prices. However, what was very interesting in this case was that the Portuguese NCAA also mentioned a very unique, I would say, theory of harm, where it noted that the restriction of the ability to conduct autonomous recruitment policies against these football players also severely impeded the quality of football games, which therefore led to the detriment of the consumers or people that attend these football games. So this, while this decision is not, however, available in English, I think it's very interesting to open it and try to translate some parts of it, because it indeed has very interesting and valuable conclusions there. Also, there's a similar enforcement activity in Hungary, where there was a no-poach agreement in place against human resources agencies, which was treated as a horizontal market sharing agreement as well. As well as there are now several enforcement against other types of labor market distortions, such as wage fixing agreements, which have been now investigated in Poland and Lithuania, and where some are now even examined in courts. So in conclusion, I think no-poach agreements are definitely becoming a rapidly emerging competition law concern, both here in Europe and also globally, having a twofold distortive effect on interlinked markets, which is an input market where the employers compete for labor, as well as the output markets due to allocative inefficiencies created. However, I think while we can definitely identify some similarities of no-poach agreements as competition distortions by objects, mirroring very large similarities with hardcore cartels, while right now there is indeed a narrow room for arguing in favor of economic inefficiencies, in the near future we may try and find out that there are more room for arguing in favor of these agreements than we may have identified right now. However, of course, we need to change our approach to the current EU competition law enforcement and the consumer welfare standard interpretation, because as we can see now, labor market distortions also affect employees as socio-economical actors, and this requires the competition enforcers to also take into effect that such distortions may affect not only consumer welfare in terms of, let's say, worsened output or lower quality prices, but also may create inequality concerns which leave a distorting an effect on economies as a whole. So that was it from me today on this relatively complex topic in 20 minutes. And I would be very happy to receive any questions later in the discussion or via my email here. And thank you so much for your time and attention.
Oh, thank you very much, Ms. Lidere, for your interesting presentation on this quite new but already very important topic. And now I would like to give floor to Associate Professor from University of Warsaw, Dr. Maciej Bernat, with a very intriguing presentation about populism, rule of law crisis, and competition law. And dear Dr. Bernat, before you're starting, a brief question about organizing further presentation. If any, we can swap my presentation with discussion, so that the discussion comes right after your presentation, so that if any you can participate in the discussion as well. Would it be necessary?
Yeah, that's. Can you hear me? Hi.
Yes, yes.
Okay.
We do hear you.
Yeah, and can you see my presentation?
Yes, we see it as well. Yeah.
Yeah, in full screen.
Yeah.
Okay. Okay. So if there is any problem, just let me know. Thank you very much. Thank you very much for your kind invitation. I'm very happy to be given this opportunity to speak to you. I regret that I am not in person in Latvia, but I hope this will happen sooner than later. And in particular, many thanks to Lauris for contacting me and inviting me for this event. So I want to talk to you about populism, rule of law crisis, and competition law. I was told that. Can you see when I change the slides, just to be sure?
Yes.
Yes.
We do see it.
Perfect. So I want to share with you some of the research findings I presented in the book that was published last year. The title is Populism and Antitrust: The Illiberal Influence of Populist Government on the Competition Law System. If you look at the cover, it suggests that there is something happening in the surrounding of the competition law system. And this may have effect on the way in which competition law system is functioning. And this topic, so the book was published last year, but I think that the topic is extremely relevant in the context of rule of law debate we have in the EU law. Maybe you follow that there is a big discussion about rule of law as the Article 2 of the Treaty on the European Union as a value. That there is a discussion about effective legal protection in the EU, and there is a discussion about independence of judiciary and certain reforms in particular member states such as Poland that might undermine the independence of judiciary. So this is also the context of this presentation. So I will focus on some on the explanation of my concept, but I am also more than happy to react and to talk about the developments in the case law. So the starting point really is that what interests me is that we have a certain kind of politicians that once they are in power, they may push forward a certain agenda. And as I said, my interest is really on how it works in practice. So what developments we may observe as far as the functioning of the competition law system is concerned. And I was looking in my research on several countries, but my focus was on Hungary and Poland, and I'm presenting to you the results of desk research, but also case law studies, but also I conducted an empirical research which included in-depth interviews in the selected jurisdiction. So let me just start, because this might be the notion populism that might be subject to different definitions. The way I perceive it is the one from the let's say constitutional law and political scientist angle. And if you look at the definition, you may have some debates what populism is really about, but it seems that today there is an agreement that the practice of populism in power, so the way in which populist governments rule, can be a challenge to the main institutions and values of liberal democracy, most notably pluralism, separation of powers, checks and balances, rule of law, and minority rights. So, and it is also discussed in the literature that the result might be a democratic backsliding and a concentration of political power, as well as broader rule of law crisis. And in terms of practice, so I am here interested really what's going on, what's happening around competition law system, and this is these are the identification of the developments I have, and they come mainly from Poland and Hungary, but today sometimes the term is used that populist politicians use a certain blueprint. So there is a couple of techniques that are used in different jurisdictions. So I don't have time to discuss this in detail, but clearly one of the key topics is the capture of constitutional courts. The questions about independence of ordinary judiciary, and in case of Poland, for example, this included the reforms of the Supreme Court, the use of disciplinary measure against judges. In case of Hungary, the introduction of early retirement age of judges as a way of changing the personal structure, I would put it that way, of judiciary. The questions concern also media capture, as well as dismantling of professional civil service. And I claim that the existence of these developments may vary, but they basically are likely to materialize. What I'm trying to do in my research is add maybe another layer that was not so much observed by constitutionalists and political scientists. So the question is really about the impact the rule of populist government have on the economy, and this might be more debatable, but here what I see is in the context of developments in Poland and in Hungary, I could claim that at least in some sectors you observe the departure from liberal market-oriented vision of the economy, and which is connected with a growing role of the state in the economy. In the case of Poland, we observe the increasing market power consolidations and concentrations involving state-owned enterprises, which are basically controlled by the state treasury, and the CEOs of this state-owned enterprises very often have very close links to the government. The situation in Hungary is a little bit different, but it also involves the change in this respect that basically leads to the situation when we can observe concentration of both political and economic power within the country. And my examples here concern nationalization and monopolization of sectors of economy. These are examples from Hungary. Consolidation in the bank, media, and energy sectors that involves SOEs. and also introduction of some loopholes in the procedural protection, for example, more limited judicial review of certain governmental decisions that lead to a significant change of the structure in the economy. So these are for me two variables I am using when thinking about the effect on how competition law system may evolve in such a surrounding. So I am thinking to what extent the decline of checks and balances and the rule of law is relevant for the competition law, and I also consider how this revaluation of the free market economic model into more state-centered patriotic model, how it affects the functioning of the competition law system. So basically, the idea is, that in particular, I think in our region, competition laws were introduced as part of the transformation at the early 90s, and it was sort of presumed that the idea at that time was free market and liberal democracy, privatization, etc. What I identify today in the surrounding is that this process has changed. So the question I was asking myself was really how competition law system is affected, and I put forward for possible scenarios that I am then studying in my book. But I want to make it more concrete. So what my empirical research suggests, I was looking at several areas and in terms of institutional side, I discussed the notion of independence of competition agencies, and I observed the processes like a politically driven appointments and increasingly limited autonomy of decision makers within the agency structure, and also at least due to some cases, and I will mention it in a minute, negative perception of agency independence. And this is actually quite relevant. I mentioned the developments in the case law. It's in February last year, the General Court delivered a judgment in SpetPro case, a very interesting ruling, in which basically the court said that a rule of law challenges, rule of law crisis in a member state may undermine a mutual trust that is necessary for the European competition network to work effectively. And basically, in this case, the General Court annulled the decision of the Commission to reject a complaint by Polish company SpetPro, saying basically that the Commission was too quick in rejecting it because it did not consider whether SpetPro can have a, let's put it that way, due process in the proceedings before Polish Competition Authority, and the Commission in its original decision claimed that Polish Competition Authority is better suited to deal with this case. So basically, right now, the Commission needs to assess the independence. This is one of the key things that is subject to the certain guidelines that the court gave. So the Commission needs to assess whether Polish Competition Authority gives independence, and there is also a question about judicial review. So just as a picture from the current case law. I was also looking at operating capabilities and observed processes like change of leaders and weak replacements. And also attrition of senior staff and staff with special knowledge. So and the problem is that probably existed earlier, but it's not a good time, I would say, for the competition law enforcement, that the financial resources are insufficient. So you have So you have certain personal changes within the agency, whereas the funds that are available are not arguably are not sufficient for a robust competition law enforcement. How much time left do I have?
I believe at least 10 minutes, I would say, but
okay.
Yeah.
Just I don't want to talk for too long. Okay, so this is institutional side. Another problem I analyzed is about judicial review, and here the question is really about the reforms that undermine the independence of judiciary. How is it relevant for the competition law system? And an illustration from Poland is that as part of the reform of the Supreme Court, a new chamber was established within the Supreme Court that today decides competition law cases. And the judges of this new chamber were appointed by a new national judiciary office, and there are big doubts already confirmed by the rulings of European Court of Human Rights whether the judicial panel that consists of the judges that were appointed in such a way, whether they can be considered as a court within the meaning of Article 6 of the European Convention. And you may read you could build similar conclusions on the basis of the case law of the Court of Justice. It's also, kind of the questions about the expertise. In the case of Poland, this reform basically moved two very experienced judges in the competition law system to another chamber. So they are not adjudicating in competition law cases, cases anymore. I'm also looking at how mandate, the scope of competences of competition agency evolves. And here I am somehow struggling with the fact that certain agencies in our region have different tasks, one of them being consumer protection, which is good. But the question is whether the enforcement under consumer mandate is somehow not overshadowing the competition law enforcement. And I also look at additional tasks that competition authorities are given. So they are, in case of Poland, Polish Competition Authority right now has really different competences, and arguably competition protection is just one of them. And you may ask yourself a question whether this is the area where that is prioritized within the agency. Then I'm looking really what's happening with the enforcement, and you could think about that as whether these changes I'm discussing within the surrounding of the competition law system and the agency as such, whether they lead or brings risk in leading to selective enforcement or selective under enforcement. So the situation in which you might have certain cases being opened because there is a political demand for such a cases, or on the other hand, the question whether you may not have some of the enforcement because the agency is afraid of being punished if it opens the investigation, for example, against a powerful state-owned enterprise. And I give some examples in my book concerning, among others, the merger review related to state-owned enterprises. And also I think it's difficult for the lawyer to study, but really the question, what kind of enforcement is not there? And if you look at the structure of enforcement, you may see the problem that competition agencies tend to focus on relatively small cases, and not necessarily the one that involves the whole national market. There are obviously exceptions, but this might be a trend. And case of Hungary is very interesting because over there was one cartel proceedings that competition agency launched in watermelon cartel, where basically the parliament passed the law that significantly limits the power of Hungarian competition authority to enforce competition law with relation to agriculture sector. And in result of this amendment, Hungarian competition authority discontinued two big cartel cases that where you could argue that the harm for consumer was relatively clear. So you know, it's this is one of the example. Another being the use of governmental decrees that are not reviewable to clear certain transactions without the scrutiny of competition authority whatsoever. And then I am thinking, okay, so this is about these two member states. I identify that these processes may exist also in other countries. So I'm thinking, what about the regional system? What about the EU law? What about the ECN? And this is something that I explore quite in detail. This Petpro case I mentioned is very interesting from this perspective, and also the question is, and probably in Latvia this is something that was also subject to the discussion, the implementation of the ECN Plus directive. I am studying the ECN Plus directive, whether it has a potential to bring improvements with respect to the challenges I identify, and my conclusion is that it might be a challenge, that ECN Plus might not help that much as one could expect. So, and this, you know, in the end helps me in offering some broader thoughts on what manifestations of this illiberal impact on the competition law system might be when it comes to different scenarios. And I'm also, this is actually the research I keep on continuing, because I think today we discussed, and that was already mentioned in the previous presentation about non-poach agreements, that the role of competition law in promoting other values than just economic welfare. So I am interested in the relation between populism and in the effects it has on democracy, and then the question about the relation between democracy and competition law. And there are two major cases concerning media market in Poland that are really showing that competition law may have an indirect positive role in promoting democracy. However, on the other hand, if competition agencies would be captured, then there is a risk that competition law is used in a way that may further undermine liberal democracy. And at the very end, I am thinking, so what can be done? Is it possible to change the situation? I don't think that you can be overly optimistic that you can build super resilient competition law system that would be free from certain negative developments if you have a certain political and economic change within a given country. But still, I am calling for enhancing the resilience, so independence of competition authorities, but connected with the rules that will safeguard the accountability, rules concerning due process and judicial review. And I'm also entering in the debate with the discussion about where the enforcement should go, because if you think about the success of populist politicians, it is because of certain economic problems that exist. So the question is whether competition law responds to economic problems of broader society. What could competition law do to change the situation? And again, here the topic of inequality is very important. And I have some further publications on that. Recently, a study on populism and public procurement and corruption, conducted together with Alison Jones from King's College London, as well as case comment to the SpecPro case I mentioned. So I'm happy to take any questions. That was quite general, but if you have more specific question, I am happy to discuss them. Thank you very much.
Thank you very much, Dr. Bernat, for your very interesting and I believe also important and topical presentation. As I said before, well, I suppose we shall swap my own presentation with discussion and to proceed to discussion right now. And if I may offer the first question for this discussion, which also could refer Dr. Bernat to your presentation. In one of the last slides from you, you mentioned about possibilities to fight this possible impact of populism to the enforcement of competition law and also competition law policy. I would like to ask, what is your opinion, also opinion of other colleagues, whether the greater convergence between practice of European Commission and national competition authorities could help to limit these risks of impact of populism to the application and also policy of competition law. Thank you.
Okay, so thank you. I think this is a very valid question. So I think we could think about this on two levels. So the first level being, some sort of different cooperation mechanism, and for example, under Regulation 1, when the draft decisions are submitted by NCAs to the Commission for its opinion. So in this case, I can imagine that there might be some help from the Commission coming that would lead to convergence, in a sense that basically you will not reach the outcomes by national competition authorities that are going really into different directions from the one you could expect to happen under EU law when it comes to the decision by the Commission. But here, I think there are challenges, and there is also in the literature what is quite discussed is the question whether we should have the same template, and there are some scholars that are in the field of experimentalism, and they are saying that maybe there should be some room for maneuver for national competition authorities to maybe take the cases and think in a slightly different way than the Commission is thinking. So I think it depends on where you are and in which jurisdictions you are. The jurisdictions I looked at, I think that if you follow such an approach, there are risks, because then there is a risk that there is abuse of, for example, of discretion that might lead to the outcomes that are driven by or linked to the political change that is discussed. And the other thing is about on the central level. So can you think about, for example, European Commission taking some cases that maybe are too difficult, too problematic for national competition authorities? And I think there is a role, and this is what I am calling for in my book. But again, I see that, for example, certain transactions in Poland that were, that met the thresholds of Regulation 139, they were transferred to Polish competition authority to decide. So that's the question, about the role of the Commission, I guess, resources of the Commission, and in interest in dealing with such a cases. And the SPEDPRO is also, I'm very curious. I'm not aware if there is already a new decision of the European Commission, but it will be interesting to see whether the Commission will basically open the case following the complaint, or it will stick to its original decision that it should be decided by Polish competition authority, and that maybe there are rule of law problems, but they don't bring risks to this particular company. So I personally am in favor of convergence, but as I suggested, you may have other authors that will have a different view and say it's good that, for example, the Facebook case was taken by Bundeskartellamt in such a novel way, one could say. Probably the interpretation the European Commission is not take. So yeah, so I think this is it's a great question that we can discuss about.
Okay, thank you very much. Is there any other thoughts of colleagues which are now in Microsoft Teams? Maybe some other questions? Oh, if not, then thank you very much, Dr. Bernard, once more for your presentation and answer. Then, in order to, at least more or less, to stick to the schedule, I would suggest that you could move forward, and then I could provide also my own presentation, and I also will try to squeeze it in a bit shorter time. Yeah, and in this context, we will switch again from the online form, or this purely online form, to this more hybrid form. Yeah. The title of my today's presentation is certain aspects regarding the rights of defense in competition law. So, and within my presentation, I will try to focus on the following aspects. Of course, I will first briefly address the question which could be considered as the main elements of the right of defense regarding the competition law. And then I will particularly address three aspects dealing with these elements. So first of all, time limits to provide response on the statement of facts sent by competition authority. Then a second, regarding the recordings of third-party interviews and oral hearings as the evidences. And third, access to the file of certain competition cases and possible collision between this access to the file and protection of sensitive information. First, about the elements of the right of defense. Of course, the rights of defense is a very fundamental principle, not only regarding competition law, but also regarding the different areas of law. And it is not a surprise that, as such, it is also provided in the Article 48 of Charter of Fundamental Rights of the European Union. As with any other broad concept of law, there are certain certain different opinions about the elements which are included in these rights, and of course I will not be able to cover them all, but as one of the, in my opinion, more solid and assessment of these elements, which I would like to follow in my today's presentation, is the one provided by established legal scholars Jan Wolters and Michal Overbeck. So, and according to these authors, there are 5 basic elements in the rights of defense. So, the first element is rights to be heard and access to the file. The second, right to good administration and duty to give reasons. The third, right to legal assistance. The fourth, privilege against self-incrimination, so quite similar with the criminal law. And the fifth, respect for private and family life. Of course, I will not be able to cover all these elements in my today's presentation. Therefore, I will try to focus on the ones which, in my opinion, from the perspective of especially Latvian competition law, are the most relevant. And the first aspect which I would like to address is a question about rights to be heard and access to file, or more specifically to the question about, which is the element within the rights to be heard, so the possibility to provide opinion on the statement of facts made by competition authority. And the main issue regarding this element is the fact that, according to paragraph 7, article 26 of Latvian competition law, there are only 20 days period for the market player to provide his reasons and opinion. And nearly in every case where competition authority is in opinion that market player may have conducted or have been involved in some sort of competition law infringement, this period of time is obviously insufficient. So basically, these 20 days you can consider appropriate only in case if competition authority comes to the conclusion that there is no violation. Otherwise, you cannot provide your opinion, you cannot provide your reasons, at least in the necessary level of detailization and argumentation. And apart from purely discussion about what kind of time limit would be appropriate, I would like to say that behind this question about days or maybe months, there are also deeper layer dealing with approach and application of competition law. As we all know, there were different schools of competition law. So initially, if especially we are looking to the antitrust law of United States, so back in history, initially they have this formal approach, but later this formal approach was quite substantially criticized by other schools, like, for instance, I believe the most important could be considered as so-called Chicago School. That is not the right approach which you can apply to competition law in order to achieve consumer or citizen welfare, as we heard today, as one of the main objectives. So you have to make economically reasoned assessment. And if we are taking this 20 days period from the point of view of a market player, so it is impossible for him to make his economical arguments based on usually detailed calculations and collection of information and other steps within this time period. So we cannot speak about real possibility to give reasoned arguments regarding effects on competition and other complex matters if we have just 20 days period to do that. And in this context, I think it makes sense to make some comparison with the time limits which are usually provided by the European Commission. So in general, European Commission shall provide at least 1 month period. But as we can see from the several cases, so basically we cannot find anything shorter than at least 3 months period. Moreover, in several cases, this period is even longer. Of course, one may say that, well, European Commission is dealing with much bigger cases, usually with or quite often with market players from different continents, usually Americas or Asia. Yeah, from one hand, of course, it is true, but as regarding to the argument about other continents and market players from other continents, well, I believe there is no dispute that the main tool for communication also for the European Commission is a document exchange via email. And in this context, really, the fact that the market participant is located in the different continent actually do not play such a big role, especially if you are speaking about period with a length of several months. And in any case, the difference between these time periods provided by European Commission and available according to Latvian competition law, to be honest, is in any case quite striking. So it really creates a question whether these provisions of Latvian law could be considered as reasonable, appropriate, and most importantly, compliant with the standards of rights to be heard. And in addition to the aspect which I mentioned about impossibility actually to provide detailed economical arguments within this time period. Another negative opinion, a negative aspect, in my opinion, created by such a short period of time, is that actually this short period of time, it does not eliminate the questions or merits. It just switches these questions from the competition authority basically to the court. Because what happens is that the market players which are disputing the decision of competition authority to the court basically appears in the court with the same arguments which would be more productively addressed still during administrative procedure, but there was not sufficient time limits for them to do so. And one more, the third negative aspect from such a short, inappropriately short period of time, in my opinion, is that actually it, in some senses, discourages the market players from intense competition on merits. Why? Because they can think that, well, if there will be a case opened against our company, then basically it might appear that we would not be able to timely produce our opinion and clarifications. Although we do have it, and therefore the decision of the competition authority could be negative for us. Therefore, then maybe let's refrain from some new innovative approaches, some new products or practices which although we believe may be beneficial for the consumer welfare, for instance, but may bring us risk of opening a case and hence the risk of facing the negative decision. And my proposal for consideration is actually to apply most likely some minimal time limit. To be honest, I think usually we shall speak about a couple of months or 3 months period. But in any case, this time limit should be decided on case-by-case basis, as it, for instance, comes from the approach cemented in the Lithuanian competition law. And very quickly, 2 other aspects. One more issue which we can find in application or enforcement of Latvian competition law is that unlike, for instance, the findings in this quite recent Qualcomm case from the June previous year, not always all interviews with third parties and also not all oral hearings of the respective market players are recorded. And actually it brings again 2 quite important and negative effects for the rights of defense. So first of all, if something which the third person has provided has not been recorded, it means that the market player could not use this information for his defense. And it appears that, well, competition authority has unilaterally decided that this information does not have any importance, although the market player may have different opinion. And after all, only the court will be entitled to say that whether this information is important and may have impact on the outcome of the case or not. The same is also to the oral hearings. According to the guidelines adopted by Latvian Competition Council, the recordings of oral hearings. So first of all, competition authority may decide whether they would like or do not find any reason to make these recordings. So it is their right, not an obligation, to make these recordings. And if the recordings are not made, then again, market player cannot use these recordings and information provided for his defense. Although, again, it is not up to the competition authority to decide unilaterally whether or not the market player could find this information useful for his defense, as it comes from the quoted finding of General Court in the said judgment of Qualcomm case. And the third aspect is access to confidential information. And this aspect has a lot of layers and interactions. It interacts with Nancy programs, it interacts with possibilities to claim damages, and also a lot of other aspects. And there is actually quite a difficult to draw the certain line. So regarding the matter, which information should be made secret from the respective market player, but which should be made available. However, at least the general guide, at least theoretical guide made by European Court of Justice, is that the decision could be based only on the information which is available also to the market player under question. Because otherwise, if the decision is based on the information which is not available for market player, he then cannot exercise his rights to defense. And that's all for today from my side. If there is any questions, I would like to ask colleagues to write them into the comment section of Microsoft Teams window. Yeah, so, but well, maybe someone will join, but otherwise I would like to invite our rising stars, and as the first, the students, and as the first I would like to invite Mr. Ryan Sivanos with a presentation about legal aspects of joint and several liability in the case of competition law infringement. Mr. Ivanos, please, the floor is yours.
Well, greetings to everyone. I would like to start by saying that this is a great honor for me to speak at this conference, and I would like to express my gratitude to all the organizers. My topic today is legal aspects of joint and several liability in the case of competition law infringements. And although there are several interesting aspects on this topic, I will focus on the two in more detail. First, I will look at the subjects of joint and several liability in the event of the infringement of competition law. And secondly, I will analyze the relationships between the jointly and severally liable parties. Article 11, paragraph 1 of the Damage Directive establishes one of the elements of effective remedy, joint and several liability of competition law infringers. In assessing joint and several liability, it should be noted that the creditor in these relations will be the injured party, and the joint debtors will be the competition law infringers. In Latvian law, joint and several liability for an infringement of competition law is set out in Article 21 of the Latvian competition law. The first sentence of the article mentioned before of the Latvian competition law provides for a broad definition of an injured party. It is a person who has suffered damages as a result of an infringement of competition law. However, are all persons who have suffered a competition law infringement entitled to claim damages? Is a person who has himself committed an infringement entitled to damages? In this perspective, a reference should be made to the judgment of the European Court of Justice in the case Courage Ltd against Krefe. This case is special in that the National Court referred a question for a preliminary ruling to the European Court of Justice in the context of a claim for damages by a person which itself was a party to a cartel. And the European Court of Justice held that a person who has participated in the infringement is also entitled to the claim damages. In addition, the European Court of Justice drew attention to the principle of equality, the principle of fair compensation, and the economic situation of the contracting parties. While it is true that these principles are important, the question I would like to ask is whether such a claim violates the principle of ex turp causa non oritur actio. The principle that an unlawful act cannot produce favorable legal consequences is also relevant in the Latvian legal system and could be found in the Article 1642 in Latvian civil law. This principle has not been analyzed much in Latvian legal scholarships. However, German civil law states that this principle must be assessed with the principle of the good faith. And the legal protection should be only granted to a person acting in good faith. In my view, it is precisely the circumstance whether a person knowingly committed infringement that should be decisive in determining whether a person is entitled to claim damages. By this I mean that a person who has knowingly committed an infringement of competition law should not be entitled to claim damages on the basis of the principle ex turp causa non oritur actio. And like the definition of victim, the definition of jointly and severally liable person is relatively broad. Article 2, paragraph 2 of the Damages Directive provides that infringer means an undertaking or association of undertakings which has committed an infringement of competition law. Looking at the principles set out in the case law of the European Court of Justice, there is a tendency to broaden the range of liable persons. First, the principle of economic continuity has been established in the case law of the European Court of Justice. This means that a company cannot be released from liability as a result of restructuring, transfer of rights and obligations, change of identity, or other transformations. Second, the case law of the European Court of Justice has established the principle of one economic entity. It follows from the case law that the parent company may be held liable for the infringement of a subsidiary company. In particular, where although it is a separate legal person, the subsidiary company does not determine its own conduct on the market and the time of the infringement, but essentially applies the instructions given by the parent company, having regard in particular to the economical organization and legal links, which unite these two legal entities. In such situation, the two undertakings thus form a single economic unit, and therefore constitute a single undertaking which has committed the infringement. Since the European Court of Justice has held the parent company liable for an infringement of competition law committed by a subsidiary, it is interesting to note that the European Court of Justice assessment in the opposite situation, finding a subsidiary company liable for a cartel entered by the parent company. It should be pointed out that nothing prevents a person who has suffered an infringement of competition law from bringing an action for damages against any of the legal persons constituting the economic unit. If the injured party wishes to bring an action against the subsidiary company, it is for the injured party to prove that the cartel concluded by the parent company concerns the same goods marketed by the subsidiary company. By doing so, the victim proves that it is the economic unit of which the subsidiary company is part together with its parent company that is the infringer. But what are the consequences of the previously mentioned principles? Well, in my opinion, only positive, because they ensure one of the main objectives of the damages directive, an effective compensation mechanism. Of course, theoretically, it is possible not to hit the target, but the legal framework creates a condition to make it a lot easier. After the analysis of the subjects of joint liability, joint and several liability, in the second part of my presentation, I will focus on the relationships between the infringers. I want to look at what happens when one of the liable parties has fully compensated for all the damages caused by the infringers. Article 11, paragraph 5 of the damage directive states, member states shall ensure that an infringer may recover a contribution from any other infringer, that the amount of which shall be determined in the light of their relative responsibility for the harm caused by the infringement of the competition law. This article is similarly worded in Article 21, paragraph 8 of the Latvian competition law. But how to determine the relative responsibility of each offender? Rectal 37 of the damages directive states determination of that share as the relative responsibility of a given infringer and the relevant criteria such as turnover, market share, or role in the cartel is a matter for the applicable national law, while respecting the principles of effectiveness and equivalence. Therefore, the criteria for determining the share of responsibility must be sought in national law. Unfortunately, the Latvian legislator has not laid down clear criteria in the Latvian competition law on how to determine the shares of liability in the event of a competition law infringement. Therefore, the solution must be found in Latvian law on general, joint, and several liability. It is well established in Latvian legal doctrine and case law that in the case of two joint and several debtors, this means that the amount of the indemnification should be divided in half. But in the case of several joint and several debtors, it should be divided equally among them. Therefore, the main guideline should be that the relative responsibility or the share of responsibility of a given infringer should be determined by the number of entities involved in the competition law infringement in equal shares. Although relationships between joint and several debtors are usually based on the principle of equal shares, Article 1686 of the Latvian civil law provides for an exception. The first paragraph of Article 1686 of the civil law mentions special obstacles as an exception to the equal share principle. Special obstacles is an open legal concept and the context of which must be determined in each particular situation. What might constitute special obstacles in compensation law infringement? The first would be a case where an equal distribution of damages would destroy or jeopardize the existence of an entity. This principle is important to respect because ignoring it leads to a result that is contrary to one of the main purposes of the competition law, a reduction in the number of market players and thus in the competition. The second proposed case for finding special obstacles is more general. Applying the principle of equal shares creates a clearly unfair situation. Such an exceptional ground has also been applied in the case law of Latvian Supreme Court. If one of those exceptions is found, the court should not apply the principles of equal shares and determine a different proportion of liability. The court could rely on the criteria set out in Rectal 37 of the damages directive, the turnover of the infringers, the market share, and the role played in the cartel. However, I would like to point out another important criteria in Latvian civil law, the degree of fault. The assessment of the degree of fault in determining the relative liability of infringers would be systematically consistent with the Latvian civil law rules on damages. That is, according to the Latvian civil law, in several situations, the amount of damages of a wrongdoer may be increased if he has acted with intentional harm. Therefore, in my view, the court should take into account the degree of fault of the infringer when determining the degree of liability. By this I mean that the relative liability of those infringers of competition law who has acted with wrongful intent should be greater than those who have been negligent. Thank you for your attention.
Thank you very much, Mr. Ivanovs, for your interesting and also from time perspective well organized presentation. Now I would like to invite Mr. Jurijs Georgs-Ruskovs. It's a presentation on synergy in competition law and sustainability. Please, the floor is yours.
Thank you very much. Good afternoon. My name is Jurijs Georgs-Ruskovs, and today I will present the presentation regarding the topic of synergy between competition law and sustainability. But before I proceed, I would like to express my gratitude to the organizers of this conference and the given opportunity to participate here today. So the structure of my presentation will be, first of all, I will draw a legal framework of the synergy between competition law and sustainability. We will see the competition law as a mechanism to tackle the issues of sustainability. Then I will address some cases, and especially the case of German car manufacturers. And lately, I will address the solutions which are proposed by European Union member states. And then I will make my own conclusions. So the introduction part is that it is not a big opening closure that there is climate change thing in the world. And there are some legal frameworks which are being tackled worldwide and especially in European Union. First of all, we have Sustainable Development Agenda 2030, where there is 17 Sustainable Development Goals adopted by the United Nations General Assembly in 2015. Also, we have the Paris Agreement, which aims to strengthen the global response to the climate change through adequate financial flows, a new technology framework, and an enhanced capability building framework. And lastly, we have the European Green Deal, which directly aims to make Europe the first climate neutral area by 2050 by setting an agenda for sustainable economic growth. Additionally, we have European Union legislation where there is an Article 37 of the European Union Charter of the Fundamental Rights, where it is provided that a high level of environmental protection and the improvement of the equality of the environmental must be integrated into the policies of the Union. And the Treaty of European Union directly provides in Article 3, subsection 3, that the Union shall establish an internal market and it shall work for the sustainable development of the Europe based on balanced economic growth and price stability. And to enforce that, in Article 7 of the Treaty on Functioning of European Union, it is directly provided that the Union shall ensure consistency between its policies and activities, taking all of its objections into account and in accordance with the principle of conferral of the powers. It seems that after such a big framework, there would be a question, where comes the competition law? The competition law comes in the next slide, where it's provided that neither the rules on abuse and dominant position, prohibited agreements, merger controls, nor other legislation directly and explicitly address sustainability issues. But I would like to quote the Miss Margrethe Vestager, who is the Commissioner on Competition in the European Union, that the Green Deal rules, taxes, and investment are the key for the Green Deal. But with so much to do in such short space of time, everyone, including competition enforcement, must also make sure that everything possible is done to help. And therefore, it is very necessary to define the field of law in which these companies are entitled to operate. For example, there is a need to provide a clear answer to the question of whether companies can cooperate with each other to jointly resolve an environmental law issue. And to do that, there are some guidelines on the applicability of Article 81 of the EC Treaty to horizontal cooperation agreements. And to take one step back, we should look at the historical perspective, where in 2001 version it is stated that environmental agreements come under Article 81 by their nature if the cooperation does not truly concern environmental objectives, but serves as a tool to engage a disguised cartel. An example, otherwise prohibited price fixing, output limitation, or market allocation, or if the cooperation is used as means amongst other parts of a broader restrictive agreement, which aims at excluding actual or potential competitors. But it should be noted that later, in 2011, in the same guidelines, it is stated that these guidelines from 2001 will not addressing the chapter on environmental agreements. However, it should be noted that in this year, in the 1st January 2023, there are new guidelines on the applicability of Article 101 of the Treaty on the Functioning of the European Union to horizontal cooperation agreements. And there is a special section for the sustainability agreements. I will shortly address some points. However, I kindly invite all the practitioners and the companies to see these guidelines in order to get acknowledged of them and to measure whether they can or they cannot take any cooperations with different companies. So first of all, it is stated that sustainability objectives can be pursued with different types of cooperation agreements, including those addressed in the preceding chapters of these guidelines. And the term sustainability agreement is in general to any type of horizontal cooperation agreement that generally pursues one or more sustainability objectives, irrespective of the form of cooperation. In paragraph 548, it is very important to note that there is a statement that when sustainability agreements infringe Article 101, subsection 1, they can still be justified under Article 101, subsection 3, if the four conditions of that provision are met. And in order to prove that, there are some cases which demonstrates that even agreements subject to the limitation of Article 101 may be exempted under Article 101 and subsection 3. For example, it was confirmed in the Exxon Shell case that environmental cooperation to reduce pollution often leads to a technical and economic progress under Article 101, subsection 3. But on the other hand, there is an examples, for example, in the consumer detergents case, where there 3 detergent companies decided to reach an agreement to coordinate the prices of the washing powders. So first of all, they made an illusion that there will be a sustainability agreement which will lead to a better future for the environment. However, there was an agreement to keep the price fixed at different stages in the market. And it was therefore found that the conduct of these detergent producers was intended to restrict such a competition, and it was considered as a violation. And specifically, I would like to address the German car manufacturers cartel case, where there is a commission decision against the Daimler, BMW, and Volkswagen for the collusion in the field of exhaust after treatment for new diesel cars. In simple words, in 2007, European legislation introduced minimum standards for nitrogen emissions for the cars, and therefore there would needed a special STR system to use that AdBlue injections to measure and mitigate CO2 emissions into the air. And the way to meet these regulatory requirements was to use such systems. And to do that, Daimler, BMW, and Volkswagen Group held regular technical meetings to develop such systems for diesel cars that meet these regulatory requirements. However, Commission noted that between 2009 and 2014, there were regular meetings where producers decided not to compete for the full potential of these systems. The sizes of AdBlue tanks and the intervals until the next AdBlue refill were agreed. Therefore, there was a common understanding that that the estimated consumption of the AdBlue tanks and commercially sensitive information was exchanged. And therefore, the BMW and Volkswagen Group had a fine of 875,000 my apologies, million euros. And however, the Daimler Group made a leniency program and therefore paid nothing. But however, it clearly demonstrates that there can be some cases where even if the main aim is to reach sustainability, however, there can be a cartel agreements hiding behind them. And lastly, I would like to address shortly the European Union member states and how the national competitive authorities tackle such an issues. And I chose the three states, Netherlands, Greece, and Austria. And regarding the Netherlands, it should be noted that Netherlands offers the national authorities assistance in the evaluation of the contract. For example, if there are manufacturers or companies who are considering to whether make an agreement regarding sustainability or not, they can simply go for the national competitive authority and ask for such an approval or denial of such an agreement. Also, regarding the Greece, it should be noted that the protecting of the environment is a constitutional duty, and there in Greece are sandboxes for the entrepreneurs, which is the safe place without any regulatory sanctions for companies to experiment with new formats to achieve sustainability goals faster and more efficiently. And regarding the Austria, it should be noted that the Austrian approach is to see not only environmental benefits that materialize immediately, but also to see the results which can be achieved in the short term. So, for example, what the next generation will benefit from these kind of agreements and actions from these entrepreneurs. And this leads me to the conclusions that the competition law can be used to ensure sustainability by allowing companies to take action to achieve sustainability. And however, competition law can be a barrier for these companies to cooperate. And balancing any anti-competitive effects, competition law can shield these sustainability measures from competition law prohibitions if they support or are in any way reasonably aimed for the sustainability. And by their very nature, agreements subject to the restriction of Article 101, subsection 1, it may be exempted under Article 101, subsection 3. However, even in such cases, it is very important to assess whether a cartel is hidden behind any pompous statements about the implementation of environmental and sustainability objectives. And the competent authorities of the European Union member states actively contribute their views and approaches on competition law and sustainability issues. And it is my point of view that a further discussion is needed on this, since we have different approaches from, for example, Netherlands, Austria, and Greece. And to tackle that, it should be noted that there is a clear need for a more unified approach, as the different national approaches individually create a legal uncertainty of companies. It was a distinct honor to stand before you. Thank you for the attention.
Thank you very much, Mr. Ruskos. Very informative. And last but not least, I would like to invite Mr. Psilianos. There is a presentation about duty of the government undertaking to enter in the contract as exception from the freedom of contract. Psilianos, the floor is yours.
Thank you. So, good afternoon, everyone. My name is, as already mentioned, Christoph Psilianos, and my research is about the duty of a dominant undertaking to enter into a contract as an exception from a freedom of contract, as shown in the presentation. Given that I'm the last presenter, of this conference, I will do my best to make my research worth your time this Friday evening. As to the subject, firstly, it is worth noting that already in ancient Roman law, at the time when the general concept of the principle of freedom of contract had not yet developed, it was recognized that the formal expression of the will of a contracting parties was not sufficient for a contract to be valid. It was also necessary that this intention is genuine. It implies consistent with the real intention of a contracting parties. Such a will also had to be freely formed in the absence of external influence. When discussing the principle of freedom of contract, professor of University of Latvia, Kalvis Torgants, who has sadly passed away some time ago, once stated, "There is no such thing as unlimited freedom. There is only more or less of it, and the amount is determined both by the possibilities of the contracting parties themselves and by the need to protect the public interests." Well, this thesis seems to strongly hold also in the context of competition law. Because of its mandatory provisions, competition law rules can, by their very nature, at least in my opinion, affect each of the manifestations of freedom of contract. For example, the freedom to choose the content of a contract may be affected by the prohibition according to which it is prohibited by a dominant undertaking to set additional terms not directly related to the main obligation. Similarly, the freedom of form of contract could be restricted by the obligation to submit a merger report, which needs to have a written agreement attached. Although the limitation of these manifestations of the principle of freedom of contract may be a matter worthy of separate discussion and analysis, in the context of this research, I have focused in more detail on the freedom of choice of contractual partner and the freedom to conclude a contract with which will be further analyzed in more detail. The duty to enter into a contract can be found both in national Latvian regulations as well as EU regulations. Nationally, Article 13.1 of first paragraph of Competition Law of Latvia provides that abuse of a dominant position may also take the form of refusal to enter into agreement with another market participant without an objectively justifiable reason. However, under the EU law, the duty to enter into a contract can be found in Article 102 of TFEU, according to which any abuse by one or more undertakings in a dominant position within the internal market or in a substantial part of it shall be prohibited as incompatible with the internal market. In practice, however, Article 102 of TFEU in regards to obligation to enter into a contract can have many forms. As the case law of the CGEU shows, abuse of a dominant position by refusing to enter into a contract without a valid reason covers a wide range of situations. For example, abuse of a dominant position in its relevant form can cover both the refusal to enter into a legitimate contract with new customers and the refusal to enter into a new contract with existing customers. In similar manner, abuse of a dominant position in the relevant form may be found where the businesses deny the possibility to supply the product to its clients, thereby penalizing them for doing businesses with competitors of the dominant undertaking. However, in the vast majority of cases, competition problems arise when the dominant undertaking competes in the downstream market with a buyer with whom it refuses to contract. In this regard, before we move forward, it should be noted that the term downstream market, or also it can be called secondary market, refers to a market that is levels below in the supply chain in reference to other products or services. But in other words, for something to be produced or served in downstream market, something from an upstream market is needed. For example, certain type, let's say, of sand could be seen as a product in primary market if it is needed to produce glass. In this example, the glass itself could be seen as a part of a secondary market. In similar manner, paper could be seen as a part of primary market for books as a part of a secondary market. From these examples, we can see that the duty to enter into a contract can be viewed as the natural consequences that arise from prohibition imposed on undertakings in a dominant position to refrain from entering into a contract with another undertaking without this legally justifiable reason. Although there have been many cases where CGEU has reviewed the duty to enter into a contract, in my opinion, that also at least partially corresponds with views of other more recognized authors, such as Thomas Eilmansberger. The content of this application is best revealed in two cases, Brunner case and EMS Health case. In extremely consolidated way, given the limited time I have, the Brunner case could be described as follows. Oskar Brunner was an editor, publisher, and producer of his own Austrian newspaper called Der Standard. In order to expand his newspaper and reach larger readership, Brunner approached Austria's largest newspaper publisher called Mediaprint, which had at the time 46.8% of newspaper market in Austria. Mr. Brunner's interests in establishing a business relationship with Mediaprint was based on the fact that Mediaprint had established a unique newspaper delivery network in Austria at the time, through which the newspapers published by Mediaprint and as well some other market players were delivered to Austrian public every morning. Accordingly, Mr. Brunner made an I should say economically reasonable offer to Mediaprint to include Mr. Brunner's newspaper in this network. Despite the economic benefits of the offer, Mediaprint refused to enter into a business relationship with Mr. Brunner, and that led for Mr. Brunner to turn to General Court of Austria to search for the court to recognize that there has been a violation of competition law and to put an obligation to Mediaprint to enter into this contract. In the same extremely consolidated way, IMS Health case could be described as follows. IMS Health was a German registered company specializing in the pharmaceutical and healthcare sector, providing data on sales of pharmaceutical products in Germany. This data was organized according to a structure consisting of 1,860 so-called bricks, each corresponding to specific geographical area of Germany. The brick structure was developed with the help of IMS Health customers. It implies pharmaceutical companies, and it became the industry standard at the time. In the end of the 1990s, one of IMS Health's competitors, Pharma Internet Information AG, started to use very similar in its core structure to this IMS brick system. In response to this emergence of competition, IMS Health sued Pharma Internet Information AG for copyright infringement in Germany in the year 2000, claiming that the brick database it had created was protected by copyright. In these cases, to answer the question whether there was an abuse of dominant position, CGEU described a number of considerations which should be analyzed to decide whether there was infringement of competition law. In my research, I have come to the conclusion that 6 general preconditions could be deduced from these cases. Firstly, it has to be concluded there is a secondary market. It implies it is necessary to conclude that there is a service or good that or product that could be imported into a secondary market from the upstream. Secondly, it must be proven that conclusion of a contract would not lead to direct competition in primary market, but rather it would bring changes into a secondary market. Put in other words, it is necessary to establish, if the contract is concluded, that other party to the contract will continue to carry on the same economic activity as it can't be, there can develop a situation where the other party to a contract will continue to carry out the same economic activity as the dominant undertaking in primary market. For example, let's say if the dominant undertaking sells a specific chemical substance, then the person invoking the duty to contract cannot decide to sell exactly the same chemical substance in the primary market. So thirdly, an undertaking has to prove that it can introduce new product or service in the secondary market. In particular, it is necessary to establish that the conclusion of the transaction will introduce an innovation into a secondary market, thus, in this way, benefiting the consumer. An undertaking cannot plead that he wishes to enter into a contract to sell something which is already on a secondary market. Fourth precondition is that it must be proven that entry into a secondary market is only possible by the use of services or network or products supplied by the undertaking in upstream market or this dominant undertaking. It should be proven that there is no other way to enter the secondary market than through a primary market service or product. In Mr. Brunner's example, if you want to deliver magazines to doors of customers, the ECGU recognized that the postal service is a valid alternative to the delivery network that Mediaprint had developed. Fifth, the duty to enter into a contract exists only if the efficient market's undertaking is unable to independently develop the service or produce the product necessary to enter into a secondary market. And this inability could be both, it could be both seen in situations where there are some intellectual property rights protecting this needed product in first level market or in other cases. So lastly, sixth precondition states that there must be no objective grounds for refusal. These conditions apply equally, at least in my view, both to tangible product services as to products and services protected by intellectual property. If the performance of a contract would not be possible, for example, because the seller's resources are insufficient to produce the additional products, the seller is not thus obligated to conclude the contract. Although these previously mentioned conditions are quite broad, it of course could still be possible that some situations would still not be solvable because of the exceptional circumstances as we can sometimes see in our everyday life. My view is that in case of doubt as to whether there is an infringement committed by undertaking, the decision should be in favor of the undertaking and not in favor of imposing a duty to contract. This is based on the fact that freedom of contract is no less important in my view than the competition law for economic development. Moreover, freedom of contract is considered to be a central element of private law, whereas the duty to enter into a contract is merely a derogation from it. In conclusion, I'd just like to point out a certain forthcoming innovation concerning the duty to enter into a contract. I would like to point out to a certain novelty in European Union law. It implies this previously already discussed, the Digital Markets Act. Article 6, Paragraph 1, Section J of the Digital Markets Act will introduce an, I would say, unprecedented innovation in EU law, a new obligation for a certain group of persons, or so-called gatekeepers, simply put, hard-to-avoid platforms that dominate the digital economy, such as Google, Facebook, etc., to contract with other companies if they request information from gatekeepers on search engine query, history, or click and view data for a reasonable fee. The Digital Markets Act does not require the establishment of the preconditions for the obligation to a contract as developed so far in the CGEU case law, seemingly thus allowing such requests regardless of the willingness or ability of the third party requesting the information to provide a new product to customers. In this respect, I suggest that in the near future, the CGEU will have to deal with new problematic situations arising from the interpretation of this Digital Markets Act. Well, I hope that the introduction of Digital Markets Act will lead the CGEU to revisit the issue of duty of contract, possibly by revisiting it in a new light and allowing it to identify new aspects of a duty to enter into a contract that not have yet been discovered. So in short, that would be final of my presentation, and thank you for your attention.
Thank you very much, Mr. Solonos. And yeah, dear participants, dear listeners, it was also the last presentation in today's conference. And as far as I see, there is no questions provided in Microsoft Teams section, right? Yeah. Well, and yeah, I would like once more to thank you very much all participants, all listeners, for your, first of all, endurance during this rather long day, and for your attention and dedication. And I'm especially proud of students of our university. You had really good presentations, and I hope you enjoyed participation in this conference. And I hope that also this experience and findings which you have made will help you in further studies and also in your future career. And with this, I would like to conclude that from the very beginnings, universities was, among all the other things, and among the, let's say, the classical role of teaching students in various sciences, universities was the place, the forum, where the new ideas, innovative ideas, and different opinions were discussed. And I really hope that also today our university, our faculty of law was such a place, such a forum, which brought a lot of interesting ideas, thoughts, and approaches about competition law. This conference will be available for in future in YouTube, in the YouTube channel of Faculty of Law in University of Latvia, for any interested person to see, to listen once more, and to analyze all the presentations made today. So, once more, I am Lauris Sasnečs, docent or assistant professor of Faculty of Law, University of Latvia, and it was my sincere pleasure and honor to moderate today's conference. Thank you very much, and have a great weekend. Paldies! Arī ārpus protokolu. Labi. Vienīgais, laikam, mācību nākošajiem gadiem, laikam, ir jātais online, jo modelis diezgan tā maza.